You're welcome. Thank you very much. I'm also PSC as well. Thank you very much. And the past chairman of the branch, thank you very much, Rebecca. Thank you very much. And also our indefatigable chairman, who is here in the presence. Please round of applause for the chairman too. Yeah. Thank you very much. Without wasting much time. Okay, thank you. It's an oversight. I have the largest senior in our list. Big Lego, thank you very much, sir. Sorry for you. Thank you very much. Okay, let me properly introduce Afan Sigwe SCL. He's a line venture, also the past chairman of NBA Abuja branch, and also the chairman of the regulation committee, past general secretary, and also an aspirant to the office of the NBA national office. Thank you very much, sir. Aspirant for the position of the president. Please, we kindly welcome him here. Thank you very much, sir. Sorry, that was an oversight. Thank you. May I also call on, because we'll be moving straight to the program. May I call on the moderator, that's the chairman of the session, Honorable Justice E. Andrew. Thank you very much. Please, you are welcome to the high table. Please, a round of applause for the Lord. A round of applause for the Lord. May I also call on the speaker, Ambassador Shegun Ogunyawo. Please, a round of applause for our speaker of today. You are welcome to the high table, please. Thank you very much, sir. Also, our discussant for today, I call upon Olani Otolani SAN, sir, you are welcome to the podium. Also, Mrs. Dorcas Neva, X-Square, the director of Multi-Door Courthouse Nigeria. You're highly welcome, ma'am. The next on the list is Laura Bismarck, Yole, Esquire. You're highly welcome to the podium. Please allow the applause for them. It's not easy for them to be here. And also our own director of Settlement House, Niger Number Esquire. Mr. Niger, you're also welcome to the high table. Before we proceed, I would like to call on the vice chairman of MBA Barnawa branch, the person of the History Deputy Manager, to read out the citation of our speaker, Ambassador Shegun Ogunyawo. Please allow me to applause for the director as he comes on stage. Thank you very much.
The moderator of this session, our guest speaker, my lords, present, NSUs, present, elders of the bar, present, the chairman of the Barnawa branch, the schools, which are part of NSUs, good morning, gentlemen. Ambassador Shegun Ogunyawo is an author, trainer, an engineer, mediator, a negotiator, a consultant, consolidator, a peace agent, psychoanalyst, conflict analyst, marriage counselor, communication expert, certified public speaker, CEDR accredited mediator, certified third party neutral, Canada, Clean Netherlands. Accredited Insider Mediator. NTI US certified. Professional in Workplace Mediation. Member Steering Committee, United Nations Mediation Support Group. That took me about 5 minutes. So I've not started with that. Oh, so I'll guess Luca is a humble man, because when I was just going through his profile, I started asking myself, it's just oil, just oil. Said this is something else. So I will stop there since the speaker will not want me to go further. So we are pleased to have you, sir. Thank you for attending this session. So at the end, sir, I think maybe the MC will have one or two words. Thank you, sir.
Thank you very much, Vice Chair. Please, a round of applause for the Vice Chair. I call on the chairman of the session to take charge of the session. Thank you very much.
My learned brothers here present, learned senior members of the bar, ladies and gentlemen, our guest speaker, welcome. I must say I'm very disheartened because we are here speaking of essence of time. And here we are, the program, starting the program more than 1 hour, 30 minutes. It shows we are not ready what we are talking about. If we are really serious about essence of time, it calls for attitudinal change. And until we do that, all we do here will just be a reduction. Having said so, time our time has been eaten. And because of that, we have to approach the time for every activity for this session, because we equally have I have another engagement and I have to be out of here. And with some of my members here on the team. So with that, I call on I had the privilege of reading the paper for today. And I want to assure you that you'll be glad to attend this session. And because the paper is rich, and with that, I call on the speaker to take charge of the podium.
Wondering if we should start by asking the I hope after I don't know what else to listen. It's really very dirty. It's okay. Especially thank the Cardinal branch of India for inviting me. Thank you. All appreciate this. Thank you. I was told that I'd like to start by 9. So I said, if you're picking by 9, I will bring my 8. But then when Madam came, she said that the judges were already there.
That's something I've noticed over the years. Once you have an arrangement and judges are going to be part of it, you would come those times before the Lord. Father, thank you. We appreciate it. I want to thank legal luminaries who are here, especially the senior advocates. I saw this morning this great man. You, we look forward to when you be there to add value and have knowledge, because you have what it takes. I talked about this morning embracing media, congesting our costs. Embracing it now, decongesting costs. I'll just skip what is ADR? Generic image is alternative to this production. Stop ADR as appropriate dispute resolution. Some see it as amicable dispute resolution. Some see it as alarming drop in revenue. I heard that first time in 2000. Young man stood up and said, "This is why I'm talking about ADR alternative dispute resolution. For me, ADR means alarming drop in revenue." Some lawyers actually say it's better than some believe that the origins from Africa. So you're talking about the congestion and costs. I'd like to provide the nexus between ADR and the multi-law courts. 1976, Professor Frank Sander, Harvard University, conceived the idea of having a multifaceted dispute resolution center within the administrative structure. So if you go to court and have options outside of litigation. Unfortunately, if you go to court, what you see is not high court of litigation, justice. So that means the options outside of litigation can claim for credibility. You have in mind that when people go to court, normally you have somebody who provides a binding, passive judgment that may not take into consideration the relationship of the parties. We all know that it's difficult to go to court and talk like the So let's do that status. So say three, but I've done five. Simplify it. One, judicial officers can affect this circumstances. Two, lawyers can affect this. Three, the parties themselves can work. Four, when there are contractual agreements specifying the use of legal options for litigation, based on that contract that particular approach the multi-law purpose. And then five, the center itself can reach out to the parties when the issue has taken interest. I'll take that again. Essentially 5 ways of getting this. One, judicial officers can reflect this. Two, lawyers can take this. Three, the parties themselves can work it. Four, when a contractual agreement specifying the use of any of the legal options for litigation, based on that contract with the dispute, that party can approach the center. And then five, the center itself can reach out to the parties when the issue has taken of the interest. I'll tell you one of the options that I personally with. But then, what are the dollars that the courthouse? Remember that the concept of the multi-law courthouse that we have within the administrative options outside of litigation. That's those options. We have mediation, conciliation, arbitration is a new concept called mediative conciliation. We have any neutral arbitration. And for multiple courthouses in the north, we also have the Sharia law that allows for parties to assist. The Niger State was invited to visit the multiple courthouse. And I noticed that the idea was to have physical doors. They had the door for mediation, they had the door for arbitration, they had the Sharia door, they had the details. That's not the concept of Professor Faxan. I was asked to comment about it. He said, for me, this is unique. We must look at things from our own places. And that is the way they see it socially deep. It makes it easier. So once you process, you know it is meditation, meditation door. You have meditators there, with arbitration, you have those who are skilled in arbitration. It's about Sharia, you go. So we will not change what people see as amenable to their ways and focus on the way the white man sees it. No, no. What you should do is to strengthen what they are saying. That is the way it must be. That is the way. I'm not telling them what Frank Sanders said. It's not what they are buying. No. Let's talk a little more now about the role of judges, lawyers, and counselors. Why do we need multiple courthouse in the first place? The time just to like and Christian, the first media job was the paper she presented in the 2002 and put in part. Sometimes cases should emanate from lower court only to get to the Supreme Court and then sent back to the Court of First Instance. We heard over again. The end of the day, the parties that exhausted, bitter, and abolished. Those are strong words. Exhausted, and bitter, and abolished. Lawyers and gatekeepers of justice system. Lawyers tell his client that there are those that are faster than achievable. But is that the dispute relationship? Client will know that that lawyer has the best interest. But is litigation really bad? Litigation is when you define ADR as an appropriate dispute resolution, you can include litigation. Why? Litigation is one of the most appropriate ways of getting dispute. So the challenge with litigation sometimes time takes. So that justice delayed, justice denied. I have a table here composed by the former vice president of this country. Let's go through very quickly. Talking about the average time in the years it takes for cases to go from the High Court to the Supreme Court. Last cases, High Court, 6.2 years, Court of Appeal, 4 years, Supreme Court, 6, total 16.2. That's the cases, High Court, 0.4, Court of Appeal, 2.5, Supreme Court, total 10.4. Criminal cases, High Court, 1.5, Court of Appeal, 3.5, Supreme Court, total 7. A 40-year-old man who has 3 cases, one a land case, another civil case, and then a criminal case, one after the other. How old will one be by the time the 3 cases are resolved? If you had to total against the 3 months, that means man would have been 74 years old. No one ever blink on the lawyer and say, what did he say? Discourage litigation. Persuade your neighbor to compromise with them they can. Point out to them how the nominal winners of the real reserve fees, expenses. Waste of time. The lawyer himself. The judge, Justice Sangradioko, what did she say about it? That the courts of this country should not be the basis where resolution of disputes. Should be the places where resolution is after all means. Resolving disputes are considered trial. Another distinguished lawyer. And later became a judge, Justice Warren Burger, what did he say? And the notion that people want black robe judges, well-dressed lawyers, and fine panel controls as a setting for the resolution of dispute is not correct. And people with problems like people with pain, they want relief, they want it as quickly, inexpensively as possible. So at the multi-doctor house, lawyers were the gatekeepers can actually take cases there. They have the right to do that. Rule 15.3d of the rules of professional conduct of lawyers, both the one of 2007 and the one of 2023. It's clearly. There is representation of his client. The lawyer shall not fail or neglect to inform his client of the options of alternative dispute instruments before resorting to continuing litigation of his client. 55.1 now says that if a lawyer acts in contravention of any of the rules in these rules, or fails to perform any of the duties imposed by the rules, a lawyer will be guilty of what? Professional misconduct. So you have a duty to expose your clients to it. When the Court of Appeal Mediation Center was established in Abuja, I was invited to address the manifest side. I don't feel like the question was asked, the question I was not prepared for. So the staff said, why do we need a mediation center? Court of Appeal. I said my mind to parrot, tracked what I said. Well, for me, it's because they have found value in party autonomy. That if it costs I should pay somebody 100,000 naira, I should give the court because they have discussion that pay 50,000 naira. The court should not insist that they pay 100,000. So the found value what? Party autonomy. That's why lawyers the one means position at the end of the day. What parties come up with are solutions that they can give and defend to the quickly now, let's look at some of the area mechanisms. Because we have time, I'll just mention them. There's mediation, there's conciliation, there's arbitration, there's party termination, judicial appraisal, evaluation, ombudsman. Now, so many hybrid outlets. Let me just focus our attention on mediation. That is my topic. For definition, you can define mediation as a voluntary, less ordered by courts, non-binding, private dispute resolution process, which the neutral person assists disputing parties to arrive at a negotiated settlement. Again, mediation is a voluntary, less ordered by court, non-binding, private dispute resolution process, which the neutral person in the mediator assists the disputing parties to arrive at a negotiated settlement. So the mediator does not decide for the parties. No. His role is to facilitate communication between them to arrive at their own solution. That's why the Court of Appeal, what will have? It's not just ADR center, but mediation center. And the Supreme Court also have mediation center. Found value at the top. That definition very quickly. You can get like 4 points. First is that the process is voluntary, so there are no forced parties to it. Second is that the process is conducted without prejudice. As lawyers are not familiar with the fact that that expression without prejudice means that any information gathered in the process is not otherwise discovered in the civil court. What's the advantage? Parties can confess. In litigation, just somebody in the dock and ask, are you guilty or not guilty? What's the default response? Not guilty, my lord. Mediation allows parties to accept that they are guilty. They are sure that that information will be used like the courts. That definition too is a private confidential process. You know it's private, but let's note please that mediation, which is conducted under a setting that's absolutely confidential. This is you. Why? Parties have their own constituencies. The man in mediation should get some adjustments says that they won't happen during the mediation session. She says that it is confidential. We all know there's likely going to be need for a mediator between the woman. So practical mediators that mediation are very likely to discuss with their husbands and their wives, their parents, with they might balance relationship with such ones. Let's note that confidentiality ends where criminality begins. Confidentiality in mediation ends where criminality begins. Why so? Mediator owes more to the society at large than to the parties in conflict. So if the agreement is such that going to cause harm to the larger society, then confidentiality ends when criminality begins. Another point of that definition is that the mediator is a neutral person. It's a school of thought that says you cannot be neutral. As you listen to a storyline, as you read one, you cannot prevent yourself from forming an opinion. There's somebody breaking you and says you should not lead. What then makes you neutral in mediation? The neutral way to conditions are like one, you have not been a party to the dispute. Two, you don't have any vested interest in the outcome. There's something I want us to do. Going forward, once you are part of the contract, please insert an APR clause. Insert an APR clause. What's that about? Once a judge or judicial officer sees that judicial officer will in the clause, you can define it, you can express it in better ways. Let's say simple form. The clause can be as simple as the parties agree that any dispute arising from this contract will attempt to resolve it using mediation, conciliation, or arbitration before litigation, the solution of the dispute. I think that's it. The parties have agreed that this from this contract will continue negotiation, mediation, conciliation, or arbitration before. Please, the other area clause, let there be a sub clause that specifies that each of those mechanisms must be activated. Again, beyond the area clause, let there be a sub clause that specifies when each of those mechanisms must be activated. Timeline for negotiation is not continuation arbitration. Why is that important? It prevents the area clause from hanging in perpetuity. Prevents the area clause from hanging in perpetuity. I have an area clause, want to go to court, but I know that area clause. And you can stay out of 8 hours 6 so that the area clause before. Let there be a sub clause that specifies when those businesses are activated. Important. And the courthouse. I said earlier that we have specific rules. For courts, until the courthouse. The lawyers, I said, no. Once I have lawyer mediation that they consider both sides of thank you for coming. I appreciate you. And they look forward to working with you throughout the process. What's the advantage? You bring them in as partners. Once there's them documentation, I'll call both lawyers. I'll tell them, if this case is not resolved today, that they want the party to go back. Don't mind. I like to put your case so that they think can be resolved. Once the two lawyers agree, they find it easy convincing their client. Once the two lawyers agree, they find it very easy convincing their clients. Or confidence in their lawyers. And once the court gave us, the parties and the different party-driven processes. Yes, they are there as observers. Quiet. Then she now beckoned on the applicant to speak. The man stood and just said, I cannot fit there here. Take me and talk. Oh yeah, fire up. And sat down. He believes that the lawyer will be able to better articulate this. So please, let us not isolate lawyers from the process. They have specific roles to play. Unfortunately, number of them are now legal compliance. So, like I said earlier, there are different specific rules for the people in. It's very quickly now. Let me go through specific rules for lawyer implementation. Lawyers are present at most. I have the time to see. Okay. Lawyers are present at most mediation. So for the mediation, the lawyer will address the party process, help select the party's representative, brief the party presenting the case they have to do a trial, assist in the selection of the mediator, advise on the need for implementation meeting, prepare the case summaries to be sent to the mediator and other parties before mediation. Identify any documents which are confidential and for the mediator's eyes only. Carry out realistic appraisal of strengths and weaknesses of the party's case. At the mediation, the lawyer will either present the case or support party against our presentation. Advise the parties throughout the mediation, possibly even lead negotiations, contribute authoritatively, find each party's partner as the best alternative to negotiated agreements. Identify legal issues that lead to an emerging settlement. Draft that the settlement of agreement. Lawyers have a positive and constructive role in mediation. They often simulate movement and flexibility. As such, they should be involved and valued throughout the mediation process. Even judges who are in their compliance have a lot of value to contest in the court. One of the former chief judges of the FCC had a case where a man borrowed money from someone else for a project. When it was done, instead of paying back, he still took money to court. He's an illegal money lender. The judge looked at him and said, "Did you borrow?" When he said yes. Have you paid? He said yes. What do you say? Mention his location. When it was the other man said, "Man, you borrowed money from mention his location." I said, "Okay, when you left your location, he ignored all legal money lenders to go and borrow money from an illegal money lender. As a judge, we're expected to descend to the arena. In this case, only going to descend into the arena. I'm going to dance in the arena. If indeed you borrow money from him, I can pay quickly. Now, because you cannot benefit from a process that you have the issue together. Quickly, otherwise you lose liberty. I said earlier that I'm watching documents. It's full of mechanisms I'm not very comfortable with. Which one is that? One is that parties can walk into the multi document. I've seen situations where a lawyer take his client to the multi-document house, only for the client to now realize that gosh, don't get without the lawyer. A week or two later, you see that client coming to the document house. The personal experience and the elderly man, like the case at the multi-document house. 3 sessions we had, the case was resolved. Was happy. Was to where my mouth was comfortable with. So around 6:15 p.m., the only question I asked was any first background. So he went, came back with cash. Imagine the relationship he had with his first bank. He didn't need to bother himself about their closing time. Following week, he called me. Daddy said I should come. I said, okay. He got to Jeopardy and he said, what you people are doing in your center. I love it so much. You know what I'm going to do? I'm going to withdraw all my cases and send to your center. I'm ashamed to say it, but I told the lie. So I said that the record that was your lawyer brought you to the multi-document house. And then your like case, please go through lawyer. Why did I say that? When the case was on, I had to charge with the lawyer. He told me he does not do any case for anyone else. Yes. That he goes from one location to the other, from Baba to Tola. Because the day he went to pick Baba in Jebu, Baba was sitting up and saw his car. Ah, is this your car? I said, yes. And I'm like, lawyer. No, they called this driver to go to the car shop. I said, pick any car of your choice. That is not the kind of plan that a lawyer should use. The man lawyers are the gatekeepers of the delivery system. A concept. So what they do development, they cannot go to a pharmacy for prescription drugs. They must go through the doctor. But people want to access it, but let them go through lawyers. Let lawyers talk to them, advise them, and pay the fee before they access the because if a client knows that could have gone to his court, that's another case. As someone else wants to go, we say, no, don't need. So let's join hands and voices together to ensure that we can protect those and lawyers are the gatekeepers of justice delivery system. The gatekeeper said we shall meet if we are related. I have the privilege of addressing you this morning. I appreciate it.
Our speaker this morning, we really appreciate you for speaking to your people despite the limited time. We apologize for the limited time that we have to allocate to you. We just shortchange ourselves by starting this program late, but we can see that we did justice to the paper. So I will call on us to give him another round of applause. He took us through the history of ADR, the role of lawyers in ADR, the types of ADR mechanisms that we have, and how ADR helps to decongest the prisons. Thank you for that insightful paper. I'll now call on my discussants to make their interventions, and I'll give 3 minutes to each. I'll start with my learners.
Okay. Good morning. My so when your teacher delivers the paper, you are told to discuss it. I put it a very serious dilemma. I remember after I became a pure researcher, I decided I should go for training in Malaysia. And because of now, we are unfortunate that lawyers, some of our colleagues resist. We are not submitting. This is voluntary. However, if we look at the rules of professional conduct very well, we think we should not encourage litigation. We should put it in mind, have it at the back of our mind, that we are taking a very serious risk. Because it is possible, in obvious cases, for it to write a formal report about the conduct of a lawyer, when the rule says we should not encourage, and it is obvious that you are the one encouraging, it may amount to professional misconduct. Let us be careful. Again, because the elevation of judges to higher courts is based on the number of reasoned judgments that are delivered. Some of them see the multi-door house as I'm a driver now. Because when you remit many cases to the multi-door houses, the number of cases that you have to give reduce. We have to find a way. However, both the High Court law and the Magistrate Court law, including the Industrial Court law, Federal Court law, specifically empowers the judge to encourage settlement among parties. I see the multi-door house as a fulfillment of the law. So, as much as possible, when files come, to me, I believe that once the judge goes through a file and you see a contract document, you should know that, okay, if there's an administrative cost, they have no business coming here. Please go to that place and sort yourself and let me do more important things. Again, it is possible that the husband and wife are agreed in their petition, cross petition of divorce, and the battle is only of the child. Custody of children, as far as I think, my own mind, notwithstanding the provision of section 71 of the Matrimonial Causes Act and section 20, which talks about the interest of the children. If the parents can agree on how best to take care of the children, that can be taken care of in the multi-door house, while the issue of the divorce petition itself, substantive matter, is left there pending, or be determined by the court as it were. 2 minutes more. Sir? Okay. One of the things I found out on which, well, is that when you are talking of mediation, you don't prevent, as a lawyer, don't prevent your client from attending. Because the client is the one that will take decision on what is best for him. You may have some agreement in principle, but in the course of the negotiation, there will be need for consideration. The client should always be there. If I have my way, clients should be the ones to talk alone. The litigant should be the ones to talk in the course of mediation. While lawyers can talk inside the country. Sometimes when these clients talk, things are easily resolved. As much as possible, and Ambassador will tell you this. Most of the crises we have borders on echo. In the course of the exact problem, okay, so, and that's only maybe the end of the story. The last issue I mentioned, or that I wrote down, there is a need for us at the process officers, whether at the Court of Appeal, at the High Court or Magistrate Court, to have this good resolution officer to assess files before being assigned to judges. I don't know whether that one will be taken care of in the new High Court that is being proposed, but this assessment is very important. Once it is done, lawyers will be guided that, okay, this matter from this person is going to multi-door house. Thank you very much. This is the interpretation I have. Thank you, sir.
Thank you, Leonard. So, with regards to the last point you made, in having been privileged to be a member of the committee, new High Court civil procedure rules, I can assure you that that provision is there. Once the matter is filed, there is a team that will see through and see the ones that are better suited for ADR and send them there. And then the others will be assigned to judges. So I give next to the director of the multi-door courthouse. Let's hear your intervention. Sorry, before she does so, while we are talking, I can see the honorable grant of the Sharia Court of Appeal work team. So you're welcome.
Thank you very much. Thank you very much. I am coming from the perspective of the United States multi-door courthouse. The doors that we have in the multi-door courthouse. We have the argument, we have the arbitration, we have the mediation door, we have the sulhu door, which is the Sharia door, we have the native door and custom door, we have now the restorative justice door, and of course the trauma and healing door. Those doors are beautiful doors that are open in the United States. I am holding a slightly different opinion about working cases. It's beautiful for lawyers to be in the place of mediation, to be at the mediation table. Honestly, they guide the process. When you have lawyers that understand the process, that are pro ADR, the process works smooth and it's beautiful. But for working cases, I know the provision for working cases is also beautiful because we're talking about time being of essence in the administration of justice. What about the indigent? Are they going to keep on gathering money before they get lawyers to come to the multi-door house? No, that's why there's that provision for workings. I'm glad to tell us that from September till now, we have filed like 120 cases at the multi-door working cases at the Kaduna State Multi-Door House. We were able to settle 89 of those cases immediately. The multi-door house also provides for training of lawyers. And I come from asking, is it possible for the bar to provide a room for the lawyers to be sensitized on ADR in Kaduna State? On basis of ADR, we have a team of professionals, a team of trained mediators, a team of trained ADR practitioners that will do this training. As I round up, I want to talk about the informality of the process. There are no, my lords, may I, yes, may I. No. The process is informal. At the mediation table, you can take water. At the mediation table, you take sweets. At the mediation table, when tempers go high, you calm down. You take recesses so that parties can calm down their tempers. Also, come from the perspective of the confidentiality of the process. Whatever happens in the mediation session stays in the mediation session. Nobody takes it out. So parties are free to divulge what is actually bothering them. Issues that are not just about the matters involved are addressed. Restoration of relationships take place. I'm also coming from the fact that it is party driven. It is about the parties. I know a session we had that at the end of the session, parties had reached agreement before the lawyer now asked, excuse me, at what point am I supposed to cross-examine the witness? So there's no cross-examination. They're talking about essence of time. For me, I think mediation is a beautiful process. I think area is a beautiful process. While the strike was ongoing, that strike, we mediated over a matter. I know the High Court was not, the ADR center in the High Court was not, but because it is about the parties, they could pick a venue that the mediator could go to and actually settle that matter. Thank you very much.
Thank you, the director of the local house. So we now know all the doors that are open to us to exploit in our mediation, ADR activities. So let's take advantage of all these laws. I call on the chairman, Shati.
Good morning. Let me start by appreciating the management of Nigerian Bar Association, Barnawa branch, for giving me the opportunity to speak in this occasion. I will just address few issues as quick as possible. Number one, the misconception of lawyers pertaining ADR. We have a lot of us who believe that ADR is actually a sign of weakness. So I've had instances where when you approach the lawyer on the other side and you say, I believe that this is a matter you can settle, and then you'll be like, maybe his case, he cannot prove it in court, maybe he has no facts, and all of those kind of things. So they see it as a sign of weakness. It is not actually a sign of weakness. It is your client's interest that is at stake. And when lawyers begin to take their client's interest at heart, I believe that clients will actually look into those kind of lawyers. And another thing is the non-binding nature. There is this belief that ADR is non-binding, especially mediation. But that issue has been taken care of when we have the Arbitration and Mediation Act 2023 that clearly makes provision for mediation. And aside from that, even the Kaduna State, the law establishing the multi-law courthouse of Kaduna State clearly states that agreements reached via mediation or ADR can be enforced as the judgment of court. Is clearly stated there, and these are laws of Kaduna State. Now, let me comment briefly on the role of judges and magistrates. Our magistrates happens to be the gatekeepers when it comes to dispute resolution, because most of the cases, literally two cases that we have, most of them goes to the magistrate, and then some go to the high court. And then the magistrate and the judges have the responsibility to know what the law says concerning ADR. In fact, in our rules, in the court rules themselves encourage the use of ADR. And when a judge and a magistrate is versatile, is knowledgeable about this, I believe that they can actually utilize that avenue to send matters and cases either to multi-law houses or to pay. I believe that our lead speaker has made mention of the fact that in the paper, judges, magistrates make referrals for cases directly to him, and he handles them. And then when that is handled, we have a process called mediative conciliation, which is propounded by a lawyer, one barrister, and law. He has been a prominent lawyer that has been patented in the United States of America. A lawyer, a mediator can have the power to take decision where the parties fail. And that is a beautiful process. So when a judge refers the matter and the parties fail to agree, the mediator appointed can actually decide the matter and then send it back to the court, and that becomes enforceable. And so it's very, very crucial and important. Now, the third matter I want to raise quickly is, just as the saying, the ignorance of the judge is the calamity of, so where ADR practitioners of law is not conversant with the procedures or what the law says or what is obtainable in ADR, it is the clients that will end up suffering at the end of it, because the lawyer just does his own matter, collects his fee, and at the end of it, the clients are the one that will keep suffering. So we are looking forward to seeing vibrant lawyers who will inculcate ADR in their practice so that clients will be safe, their interests will be protected when they come to us. And the issue of enforcement. Now, we have the provision in the new arbitration and mediation arbitration act that clearly talks about enforcement. That agreements reached either in mediation or arbitration can actually be enforced. We don't have problem with arbitration awards because they are clearly enforceable right from time. But now, even at the arbitration table, you discover that parties can actually reach an agreement and then file it like a terms before the arbitrator, and the arbitrator will adopt it as his own personal law. So it means that even in arbitration, negotiation and mediation can take place. It's just that a mediator, you cannot serve as a mediator as well as an arbitrator in the same matter. That is one of the clear provisions of the AMA 2023. Now, it says that these agreements reached by parties can actually be enforced as contracts, as consent judgment, and as consent awards, clearly provided for in the act. So this is something that we can actually use to encourage our clients. Even before now, you know that when parties reach an agreement, that agreement can be enforced as a contract once they sign. So to talk of when it is reached before a court, the court can adopt it as consent judgment. And one important thing I want us to note is the fact that you see that where a matter is decided by the court, it is a constitutional right of a lawyer or a party to appeal. But you see, when it comes to area and a matter is decided and is entered as consent judgment, the possibility of appealing is actually very difficult, if not totally eradicated. You see that the issue of appealing to the Court of Appeal and then National Industrial and maybe to the Supreme Court has been taken care of, and this is very, very critical for us as lawyers. Finally, one of the major and important aspects of the thing that was raised in the paper is the issue of training and training and training. Very, very critical. You know, we have the panelists that are almost faculty members of different institutions that train and certify in alternative dispute resolution. Now, I must commend the Nigerian Bar Association proactive steps they have taken. I've attended personally 3 trainings on ADR that have been conducted by the Nigerian Bar Association through the national, and it is free and available. It's so disheartening that most of the lawyers are not taking advantage of it. And you can see people who are non-lawyers are taking advantage of those trainings and they are attending, and you have experts coming on. Now we have trainings that just conclusions. Now, in conclusion, you know, I want to quote Justice of the State Court of Appeal, who says that the integrity of the processes of the area process rests on the shoulders of those who administer them. So competence and continuous training are crucial to ensure that justice is both done and seen to be done. Now, where lawyers do not avail themselves, you know, to take part in trainings, aside from the free trainings, take up certification trainings. It is expensive, but we have platforms which were made available, subsidized training for lawyers, and I believe that when we take advantage of it, it will be great. Thank you very much.
Thank you for your interventions. It's very critical points. Hope we take note of them and take them to heart. Our last speaker is somebody we all know to be very passionate about ADR. It's always very exciting and inspiring to hear her talk about ADR. That is why I left her purposely to speak a speaker. So we will hear our last speaker, Madam Laura.
Thank you very much, my lord. Good morning, everyone. I'll commence with something from the former CG of Lagos State, Honorable Justice Oke. He said, in ADR environment, the lawyer is no more a courtroom advocate, but does not become less than he is in accomplishment as a litigator. He has to deploy a fresh set of skills to demonstrate mastery in this new arena. He must become the legal advisor and a strategist and negotiator. He's in the negotiation to make deals for his clients and not to advocate rights and legal position. End of quote. So while we keep talking about ADR and where we've met some resistance from some of our colleagues, we're here to tell us that ADR is not a drop in the revenue at all. It's additional skills for us. And so that's why we keep advocating, let's have more training, let's have more skills as lawyers. Because the truth is that if there's anything COVID taught us, it taught us to realign. When you have more skills, it's for your benefits. You never can tell when those skills will be useful. In fact, in the appointments of judges, a lot of them were able to stand out because of these additional skills they have. My Lord Justice Kobo, in most of some of this international, you see him being called as a facilitator. That's an additional skill. So it doesn't take anything away from us. It doesn't distract us from it. And so that's why we really want to appreciate the director of the multi-law courthouse. The courthouse was in comatose for a while, but we thank God with our coming on board, we've seen a lot of changes. The place has been rejigged, and she's really doing a very good job. So the multi-law courthouse has woken up to its responsibility in delivering justice. And so that's why I will come from the angle. The third Kaduna settlement week is coming up in July, 22nd to 26th. We have the first, we have the second. This is the third coming up. It's an opportunity. We were in Lagos last week, and a matter that has lasted 39 years in court was resolved. It's not in any way going to dwindle our resources at all. That's a lie when you think. So please, we are calling on all lawyers. Key into it. It's a moving train. Is it that you hop on or you get left behind? So please, let's make sure that we own our skills. Any advantage, we use money looking for money. You never can tell when you have opportunities. So please, we plead with all of our colleagues, make sure you come up on board. Cases, you have your ADR clauses, you insert into documents, consent judgment, enforceability, settlement agreement. So practicing lawyers with negotiation skills can make money as neutrals, arbiters, and rest. Just for your fee is protected. Please know that your fee is not in dispute at all. So please, we encourage each and every one of us to make sure that ADR, we use ADR in doing what? The essence of time is very, very important. Kaduna State has introduced the trauma healing restorative justice. In courts, nobody cares about your emotions. Yes, you've won. What happens later? A lot of parties have traumatic experiences, a lot of issues. Even when you have issues in some criminal matters, compoundable offenses, these are all matters that could still go through ADR. What happens to the feelings of parties? As a lawyer, which is interested in ending now, we really care about the welfare of the parties. So when you come to the multi-law courthouse, we've seen a lot of emotions where parties cry. We've seen people come up and say they want to go through divorce, where the other party is just giving attention, just wants to be heard, wants to vent, and wants to talk. So these are the avenues that the multi-law courthouse presents to us. Parties are able to speak, parties are able to cry, parties are able to bring out kinds of emotions. And at the end of the day, they say thank you because they really appreciate you. They know that you're not just there to get money from them. They know that you actually care for them. And when a client knows that you care for them, that client can never leave you alone. The client will always seek for you. So please, we plead with us all. Let's make sure that we key into it. Kaduna State is moving. If you don't hop up, you'll be left behind. But I'm sure you will not be left behind.
Thank you, Laura, for that intervention. I expected nothing less. And I thank you all my discussants. At this point, I will take few interventions from members of the public before our lead speaker will wrap it up. So I want to see, let me know how many interventions I'm going to take. 1, 2, 3. Okay, 3 interventions. After this, no more. Then we'll take the
Thank you so very much.
I always enjoy discussions. You said alternative school resolution. But the reality is that one, the judges themselves and the courts are not ready. The judges are sometimes afraid of being accused of selling into the area. And the lawyers don't help matters like when they see that the case is bad and there's a hearing by the judge, and it's not a matter for the court. The right petition to the judge to the NJC. And NJC, without giving a proper information, even in the silliest of circumstances, require a judge to answer and sometimes to hear. But for me, the saddest part of it really is that the very reasons why ADR is a preferred mode of resolving disputes are the very reasons opposite now in Nigeria. It's no longer cost effective. If you go for arbitration, the lawyers who are involved in it, the arbitrators, first of all, will ask a percentage of what is being claimed. And it doesn't matter that they may never grant it. And the clients bother that they will be required to deposit costs for arbitration fee. They have to pay the lawyers to become very expensive. It's no longer time effective. It becomes highly technical. And sometimes it is easier to enforce a judgment to the court than an arbitral award. And these are problems. Of course, our rules of court are not meant to help you. Lagos try to introduce a very preferable to mediation. All the lawyers they just go there frustrated, and sometimes you see a case taking up to a year or more to get back to court for trial. So I think first of all, we need to change our mindset. Our courts need to be prepared for parties to resort to ADR. And the policy of the court that it is wrong to impose cost on the losing party should be reviewed, because some cases are so frivolous that nobody, right thinking person, should take them to court. But because people know that there are no consequences for bad behavior, people sue even when they know there's no reason. A man is owing you rent, you have not done anything. He said he wants to throw me out. People sue in court so that he cannot take. We have been talking about different. Or he said the house belongs to him. The absence of it is there in court. And at the end of the day, the court simply dismisses his suit without assessing the cost incurred by the defendant. We must find ways of decongesting our courts, making it cost effective, and also ensuring that people do not labor the cost with cases that have no business being in court. Thank you so very much.
It is common knowledge that there is no human endeavor that comes without challenges, no matter how beautiful. So ADR cannot be an exception. So as we discussed like this, the challenges will come up before. Then we'll see how to surmount them. Thank you again for that. Who's the next? Mr. Asogwa.
No, actually, the other side spoke along the line of my policy. Because some years back, there was a clause in a contract, and we took to the The first thing they told us is that we have to pay for the day. The high court premises. Secondly, that we have to pay for the administrators or the arbitrators who do the arbitration. Thank God, my case was resolved in a short time. But when we finished, asked my parents, what was my own? He said, they're on again. See, can you see what I have spent? I paid for the venue, I paid for the people who came for arbitration. Oh yeah, please, you just have to understand. You don't have to spend the whole money. So this is the challenge, as you can say. We are looking for a place where we get things easier. Yes, we have had the case resolved within a short time. But you have spent more than 5 times what you ought to have spent going to litigation. So it's a challenge. Another issue I want to raise the law is, it's like the law is a bit weak. It takes us simple as saying, I'm not proceeding to litigation. And that's all. I don't want to do ADR. And nobody knows anything about it. It should be strengthened. It should not be left for you to have a choice whether you want. The law should be that this case ought to deal with ADR. And that's it. Thank you, Lord.
Mr. Asogwa, the lady over there. That's the last one.
My Lord, the moderator of this session, I get to stand on existing protocols. I would first of all want to appreciate the lead speaker who gave us a very deep insight of what ADR is all about. I am deeply grateful. I would want to look at it from the point of view of the lawyers. I've had to have discussions with a lot of lawyers on ADR related issues. And I discovered that lawyers have this apathy to ADR. And the main reason is because a large percentage of lawyers think that when you go for ADR, you lose your fees. Just like what my learned senior, Mr. Sowa, said, by the time some of the clients spend some of these ancillary fees, and looking at the fact that throughout the session of the ADR, it keeps occurring, or the mediators and the arbitrators keep ringing it as a bell that it is about the parties and not about the lawyers. And most times, the lawyers don't even get the opportunity to speak. At the end of the day, clients would ask the question, it was about us, you didn't even say anything, and then the lawyers lose their fees. I think that is the main reason why lawyers are apathetic to getting involved in ADR as a procedure. And I would want to suggest that there should be sensitization and resensitization, where lawyers are sensitized of the fact that they can still have their fees even before going to ADR and after going to ADR. And that is where the culture of charging consultation fees should be encouraged. Because there are a lot of lawyers who think that if they do not file papers in courts, that they will not earn their fees. And I think that is the reason why we have a lot of frivolous cases in courts. Because they think it is by filing those papers that they can earn their fees. So I agitate for sensitization, constant sensitization of lawyers on the issues and procedures of ADR, hammering on the fact that their remuneration will be secured even at the ADR. Thank you very much.
Thank you for that intervention. So right now, I'll give the lead speaker 5 minutes to comment on one or two of the interventions.
Thank you. Three things I want to say quickly. First is to commend the director of the Kaduna State Hospital. Madam, we introducing restorative justice. Well, I don't think there's any more to know for that. Restorative justice, the attorneys general from the southeast states, was when I had a summit, invited to now everybody states has passed the law for prison farms. So where the prisoners can farm, process whatever government divided into 40% is kept for that prisoner. 40% is used to take a prisoner from the correctional center. The 20 goes there as IGR states. So now bringing to the budget of what I'm like, my sister mentioned about people's emotions being taken off. Just listening to people is a bit. I had the station, so thank you. About walk-in cases. I've seen situations where the lawyer brings his client to a multi-house. Then a week later, the client is calling me directly. He mentioned the indigent. Lawyers have permission for problem services. In Abuja, before you take a case to court, you sign the certificate of the action consent, signed by the lawyer. You can introduce yourself, even for such problem services, because lawyers will remain the gatekeepers of justice in the system. If they are isolated, we see their client at the bottom of the way and be frustrated. One of the things I've learned over time is that our ability to put ourselves in other shoes makes us better humans. The lawyer has spent years, plus school, plus one university, comes out and cannot assess the quality of what has he or she can be frustrating. For those who are charging, I think one challenge for lawyers charging is that we have been talking about ADRO, saves time, saves cost, saves a lot of things. A lawyer can do it differently. A client comes to you as a case, can assess the case. When the client comes to you, the client wants to go to court, assess, provide a fee, and then tell the client that from my experience, maybe this can take 2 or 3 years. If I can get the case resolved in a month or 2, how much more would you be willing to pay? Especially for cases that have value for time, time value for money. I'll take that again. This was talking about ADR, being cheap, doing that. Take it up as if you are going to court. They tell the client that if there's a way I can get the case resolved in a month or 2, how much more will you be willing to pay? So it is expert service. That's what ADR is. So you can get money from that, but for the indigent, like Madam has mentioned, to be able to provide pro services. But I'm thinking that like the two that which are going to sign the certificate of reaction consent should also be one that when that party is coming, there's a lawyer that has already. It will make the lawyers feel that ADR is that or they are part of it. And for mediators who have opportunity, let us not deny lawyers active participation in the process. Once you ask a lawyer to step out from outside the same please do not accept it without the consent. From outside, it's not controlling. Once we have lawyers in it, let's appreciate their presence. Thank them for coming and tell them that we look forward to working with them throughout the proceedings. For giving me this other opportunity, sir. You. Thank you.
So I thank everybody, my panel of discussants. Thank you for your interventions. Ladies and gentlemen, thank you for listening and the interventions we got from the public. With this, I call this session to a close.
Thank you very much, Mayor. Please round of applause for honorable trustees and the chairman of the session, and also a round of applause for our speaker, Ambassador Shegun Okuyomi. Please a round of applause also for the speaker. Thank you very much. May I seek your leave? May I seek your leave before the certificate presentation of certificate of participation to quickly recognize those in our presence. Please, may I formally recognize the Grand Kadi of the Sharia Court of Appeal, Honorable Justice Mohammed Ali Benjuma. Please allow for me. Thank you very much. May I also recognize Peace and Castle. Please allow for our presence. May I also recognize our very own Tajuddin Olajuja, SAN Life Venture. May I also recognize Dr. Murtala Abdurrashid, SAN, Thank you. And also our movie in the house, Ada Elejo. Please a round of applause for Ada. Also, we have in our list the past chairman of the branch, that's the person of Abdul Wasiu Alfa. and also an aspirant to the office of the General Secretary of the country. This is not purpose for me. And we have in our midst also the chairman of Keki branch, the president of Lungu area. This is not purpose for me. And also accompanying the grand cardinal, we also have the cardinal in our midst, Abban Ibrahim. This is not purpose for me. Thank you very much. I will have our own learned senior SB Mohammed in our midst. This is not purpose for you. Thank you very much. May I invite to the chairman for the presentation of certificate of participation.
Without the chairman of the session, I started on the existing protocol. We once again welcome all of us to this morning's session. We would have done every other thing apart from giving these labs and the certificates, but unfortunately, the chairman of the session, the Honorable Justice E. Andrew, the legislature, our own Dipotolani, and the director of the Multi-Door Court House, will be having an appointment with the Honorable Chief Judge of the state in a few minutes now. I think they are proceeding to Zaria or somewhere. So he begged that we should permit them after this for them to take their leave, then we'll proceed with the rest of the program. I think that is acceptable to us. Thank you. So now I'll call upon the Honorable Grand Kadi to come up stage to help us on behalf of the branch to present this plan to the lead guest speaker, Ambassador Shegun Munyawu. My Lord.
I think before I do the handing over, I want to say a word or two. I'm an ADR man. I was the primary director, deputy director, Solu ADR Center, Kuna. And the Ambassador Shegun was my lecturer when I had my training as an associate at ICMC. So it's an honor and privilege for me to be here handing over this flag on behalf of the model branch, Nigerian Bar Association, Barnawa, to him in recognition of his contributions to the development of mediation in particular and ADR in general to the Nigerian nation. On behalf of the model branch, I hereby present this flag to you in appreciation of their contributions.
Thank you very much, my Lord. We have to present certificates of participation to some of our discussants and contributors. May I call upon the Honorable Justice Darius to kindly come up stage to help the model branch present these certificates. My Lord. The first is to the chairman of the session, Honorable Justice Edward Aldo.
My Lord and my brother, on behalf of the Nigerian Bar Association Barnawa branch, the Amiable Model branch, presents this recognition of your participation as a on the topic embracing ADR in the congested our courts during 2024 annual. Thank you very much.
We are not discharged yet. We are going to present to the director of a state multi-court door house, Mrs. Douglas Taylor.
On behalf of the Barnawa branch of Nigerian Bar Association, in recognition of participation as a discussion on the topic embracing ADR in contested courts, we present this certificate to you, Mrs. Dorcas Lady Esquire. I would want to say something. Any assignment you give to Dorcas, she will discharge that assignment very well. I say so because she's been a member of so many committees that I chair. I know her valuable contributions to those committees. So I'm not surprised. Thank you.
Next is our own Sheikh Oladipo.
I will expose a secret here. When I came in here yesterday, I saw a Garnet Silk and a Baker, and I whispered to them just like 2005 said yesterday. I held them together and I said, this is the powerful 2008 set. 1988 set, sorry. Oladipo Tolani SAN. We've been together for the past 35 years. In recognition of your participation as a discussion on the topic embracing ADR contested courts, it's about 40 years now. It's a long time. In recognition of your participation as a discussion on the topic embracing ADR contested courts during our 2024 Law Week, I present this certificate to you in honor of participation.
The next, Laura Bismarck Emerole Esquire. Hello.
Distinguished participants, this is another amiable person. Laura is the secretary of the Small Claims Court, of which I chair. She will never let me sleep. She never did until we saw to the establishment of the Small Claims Court. Laura, you are quite amazing. By the way, thank you so much. In recognition of your participation as a discussant on the topic of wrestling here in the congested courts, on behalf of the Barnawa branch of the ABA, we present this certificate to you during the 2024 Law Week.
You know, as a matter of fact, all the participants, I can say they are all my trainers, teachers in the administration courses. I can say the one we're going to present next is a member of our branch. We cannot take him for his age anymore. Rather take him as my teacher. He is a non-child expert.
Non-child number. In recognition of your participation as a discussion topic embracing ADR in congested courts during the Barnawa Law Week 2024. On behalf of your amiable contribution, we present the certificate.
Thank you very much, my lords. And on this note, we are not closing for the session, rather, we permit Honorable Judge and State and the Director, when they leave, the organizers will tell us next program we have now. But permit us for them to leave. So, my Lord, thank you very much for that. Sorry, good photo. Good photo. The Grand can join us. My lords, please join us. The night lecture, let us say, please come to the stage. And we equally have the opportunity of welcoming NSC that arrived from Lagos just now, Chukwuka, Ukwazo, Senior Director of Nigeria. Welcome. Please, can you come up stage? We are also NSC and former General Secretary of the National Bar Association, Maazi Afaposi. Please come up stage. The father of the branch, Patrice Ekasomome, please come and give them honor of being in their mission. Then please come up stage, Dr. Abdulrashid Ladimeji Ure, SN. Please come up stage too.
Thank you very much. Please, a round of applause for the discussant, the learning sake, and the Lord's presence. Thank you very much. Before we move further, we are going to be having goodwill messages from the aspirants in our list. We have Daniel Singh, Alpha Osigwe, SAN, is vying for the post of the president of the NBA, is going to give us a goodwill message. Please a round of applause. And also we have Chukwuka Ukwazu, SAN, is also vying for the position of the president of the NBA, is going to give us a goodwill message. Please a round of applause for him too. Thank you very much. We also have in our list Abdul Matiu Alfa is also vying for the position of the General Secretary. He's going to give us a goodwill message. Please a round of applause for that. Please, we'll give you two minutes each for us to save time. The essence of our being here is the essence of time. So let us manage the time properly. Thank you very much. Sir, I welcome you to give us a goodwill message. Please, a round of applause for the Daniel Singh. In Nigeria, we say that time is one.
So when you have time, somebody needs to speak, you better be first in your face. I thank the AMA for inviting me to this for week. Unfortunately, I couldn't make it for this ceremony. I find the theme of this year's law very interesting. The essence of time in the institution. We are taught that justice delayed, justice denied. And so for any system that needs some justice, in which time does not mean where people spend intolerable times, maybe sometimes do not live long enough to enjoy the essence of resorting to that system. Such a system will never have the confidence of people. And so when we focus on it, it's because we have the imperativeness of giving to time, of ensuring that our decision of justice system does not only give qualitative justice, but one that is cost effective and is also time sensitive. And so in our society today, it takes an average of about 12 years to a matter judgment law. Maybe you can remember the Barnawa branch to say that all of us should leave this law with a firm commitment to ensure that there is timely delivery of justice, and that all of us must know that the perception of our judicial and legal profession in Nigeria is heavy. That is all of us have to take a conscious effort to be sure. And we show it up by doing the right things and ensuring that we spend good time and our clients go away happy for resorting to the legal machinery for resolving their dispute or solving their problems. Thank you so very much for giving me this few minutes to give me this good message. Thanks and God bless.
Thank you very much, Madam. Please, a round of applause for the Nagase. Thank you very much, sir. May I also welcome Chukwuka Ikpeazu SAN on the podium. Please, you are highly welcome. Please, a round of applause for the Nagase. Thank you very much.
The chairman of the Barnawa branch of the Nigerian Bar Association, members of the executive committee, live benchers, senior advocates, past chairmen, leaders of the branch, distinguished colleagues, good morning. It's my pleasure to be here this morning, and I thank the leadership of the Nigerian Bar Association Barnawa branch for this opportunity to be part of this event and to give a goodwill message. Barnawa branch is a place where I feel at home. Many of you will remember that last year I attended the dinner of the branch and I had the privilege, and it's not something that I take for granted, of giving a dinner lecture. And I'm happy to be here again to be part of this law work. Many of you would know that my branch, the Nigerian Bar Association Lagos branch, is also holding its own law week. In fact, the opening ceremony was yesterday, it's continuing today, but I thought it was important to, excuse myself from that law week that's taking place at my branch to be here, and I'm happy to be here. Thank you very much. Thank you. I've seen the theme of the law week. I think it's apt. Not too long ago, a retired justice of the Supreme Court of this country went before an arbitral tribunal in England to give evidence that on the average, it takes about 15 years to resolve a simple commercial dispute from the High Court to the Supreme Court. And many of us will agree that 15 years is actually very conservative. It takes a lot more than that. And this undue delay is what has contributed to the dysfunctionality of the court system in Nigeria. And this is impacting us as lawyers in different ways. At a very basic level, if you're a small-time practitioner and you bill 200,000 to recover premises, if you're able to get into a magistrate court and come out in 3 months or 4 months, the money will have a lot more value in your hands
than when you're stuck in the court system for 6 years, which is our current reality. So I think that it behoves on every one of us to do all that we can to ensure that this undue delay in administration of justice is eliminated. So I thank the MBA Barnawa branch for selecting this very important topic. I have no doubt in my mind that the faculty that has been put together to discuss this topic do justice to it, and that after this law week, all of us and the legal profession will be better for the discussion that will take place here. So once again, I thank the leadership of the branch for this opportunity to be part of this event. Thank you.
Thank you very much, Nancy. Please a round of applause for Nancy. Thank you very much. They are also welcome to the podium the past chairman of the Maiduguri branch for his goodwill message. He's vying for the position of the GS, General Secretary.
Let us see advocates of Nigeria present. The chairman of Barnawa branch and other members of his committee and Leonard colleagues, a very good morning. I bring you greetings from the Maiduguri branch of the Nigeria Bar Association, where I come from, where I previously served as the secretary, chairman, and director. It is indeed a real privilege for me to stand before you this morning as you gather to brainstorm on a very important topic, the realm of arbitration. As we all know, arbitration is not something you just become qualified in, except you undergo some kind of training, which will expose you to some nitty-gritties of arbitration. So I want to advise is that after this law week, I really want to advise that we need to add a professional feather to our cap by joining some kind of training, the realm of arbitration, either online training, either physical training, or any other thing that would enhance your skills in the realm of arbitration. As we all know, being a legal practitioner per se is not enough for you to be a qualified arbitrator. You must somehow learn the ropes for you to be identified. And I can tell you for free, without the requisite skill in arbitration, no arbitration proceedings will come your way. Because for you to be an arbitrator, you must be qualified, and you must not only be qualified, you must make your mark in that field of arbitration for you to be recognized and for you to enable you get that kind of brief that will leverage on your practice. So it is my sincere hope and belief that at the end of this program, we will be well equipped, we will be well encouraged, we will be well motivated to enhance our knowledge and skill as we develop our practice. Thank you so very much for listening.
Please, a round of applause for the past chairman of the Maiduguri branch. Finally, I will call upon Zainab, a representative of Oba, to please come on the podium to give us a good message. The person of Funke Bamikole, thank you very much. Please, a round of applause for her. She's representing Zainab at Oba. Thank you.
Good morning, all. Please permit me to stand on the already existing protocol. And I want to appreciate the chairman of this branch for giving me this wonderful opportunity. I'm here to represent Zainab Aminu Garba. We all know as Zainab Atoba. She's vying for the position of third vice president of Nigeria Bank. She would have loved to be here. She's in Lagos. In fact, when she's to me to come and represent her yesterday and today, but in my office, we were having a program, I couldn't make it yesterday. So I told her, is there any need for me to go to? They said, no, I should come. This branch, I hold them dear to my heart. And I have to leave everything I was doing to come here today. Yes, she owed you so much to her heart. You are so dear to her heart. I want to tell you that Zainab Aminu Garba, she's a beautiful lady. She's beautiful both outside and inside. And I want to assure you, the trial will convince you. A vote for Zainab is a vote for progress. More importantly, mentorship so dear in her heart. Give her that opportunity. And you see the topic, the essence of time in the administration of justice. I want to first of all commend this branch. Despite the rain, many of you came on time. You know, time is of essence in our profession. Well done, thank you. If you give Zainab the opportunity, it's just you will be taken to your bank.
Thank you very much. A round of applause for that, please. We have finally come to an end of this interactive session. We are going to be having tea break, but please, from the first table, the first room, they'll be flying out to the place. Let's make it orderly. The rest will be seated while our learned seniors, the learned sick, the beloved in our presence will file out to the table for the tea break, while others just sit quietly if you get to your turn. Thank you very much. DJ, please give us a background music. Thank you very much. Please, we can find out for the tea session, for the tea break. Thank you. Thank you. Thank you. Thank you. Please, if you have been served, please can keep seated. We are about starting the next session. Thank you very much. Thank you. Please kindly be seated. We are about starting the next session. Thank you very much. Do maintain some level of quietness behind this. Thank you. Before we proceed next session, let us see. I want to take a group photograph. Okay. Before we proceed, we would like to take a group photograph with our guests before they leave. So let us have a group photograph before they leave. I'll be calling on them one after the other. Let us see. Alpha Mosigwe SAN, please a round of applause for them as they come out for photograph before they will leave. Lionel C. Chukwuka Ikweazum SAN, please for a group photograph. Our guest, please on the podium, please. Our new speaker for the first session, Ambassador Sheko Ogunyewo, please come to the podium for a group photograph. Our very live lecturer, Tajudeen Olajuwon SAN, sir, please podium for a group photograph. Our Lionel C. Dr. Murtala Burashid SAN, venture, please group photograph. Our daddy in the house, please, and Casanova. The live venture, please. I've been corrected. It's no longer a venture. Our Dr. Murtala Burashid SAN is now the live venture. Please a round of applause for that, please. Alhaji. Thank you very much. Please, and Casanova, daddy, please group photograph. And exit now to the past chairman of the town branch, please group photograph. The magistrate here present, please. The magistrate here present, I will not have your great. We have his worship, we have his worship, Alex Agodi. Idris Mohammed, please. Kindly come out to the photograph. The magistrate here present. The judge from the customary court, you are here, please. Group photograph before our guest is finished. Have some on our iPad. Thank you very much. Thank you. Please, you have a very nice senior now, please. You know that, please. Man, you can please step out, please. Video, everything I want, please. BSC and sofa. Please, you can step out. And that's the lecture, please. Photograph. Up to Wasim, the past chairman of Medicine Branch. See here? Please, group photograph, please.
Give you my number so that give me your number. Okay, Hama.
Thank you very much. Thank you. Please, a round of applause as they go back to their seats. Thank you. Thank you very much. Thank you. Thank you very much. Thank you very much. Thank you very much. We are moving straight ahead to the next interactive session. Thank you very much. May I use this opportunity to formally commence the next interactive session. I'll be calling the chairman of the session, Idris Mohammed X Square. Please come to the podium. Please a round of applause for Idris Mohammed. Thank you very much. Our speaker, Abimo Toyosi Olu Yewola Esquire. I was reliably informed that she's here present because the session is going to be an online interactive session. She sent her apology for not being here with us, and I hope you are going to enjoy her interactive session. Thank you very much. I'll be calling on Sharon Yabo Kuyet. Please a round of applause for the discussant. Sharon, please come to the podium. Frank Ijege. Mr. Frank Ijege. I'll also be calling on Alamin Abubakar Esquire. Please, if you are here, come to the podium. A round of applause for him. Before we proceed, we'll be taking the citation of the speaker. The citation of the speaker of today's session. I'll call on the vice chairman of the model branch and the person of Ehizoke Felix Imadijemu. Please, the vice chairman, please come forward. He will be taking the citation of our speaker. Please, the essence of time is why we are here. Let us see how we can manage our time and use it judiciously. Please, a round of applause for the vice chairman as he comes on the podium. Thank you very much.
Good afternoon, everybody. Please permit me to adopt the existing proper protocol. Our guest speaker, Abimo Toyosi Olayiwola, is the principal partner of Abi Legal Barristers and Solicitors and founder of Digital Lawyers Network, a community of about 4,000 digitally savvy lawyers across the world. She is a business lawyer, a digital lawyer, and a digital law practice consultant who helps lawyers leverage the internet and social media to build a profitable legal practice. As a digital lawyer with passion for delivering legal services through cutting-edge technology, she coaches lawyers, some of whom are senior lawyers, highly respected professors of law, on the necessary skills to run a profitable digital law practice. Her passion has driven her to speak at various gatherings of legal practitioners on the need to embrace digital technology in delivering legal services and to leverage the internet and social media to build profitable legal practices. She also consults for law firms about online reputation management and digital law practice. In recognition of her depth as a technologically driven lawyer. Her mentor, Mrs. Fumi Roberts. Fumi Roberts and the pioneer of cadre initiative, president and board of the steering committee of cadre, an online alternative dispute resolution platform that seeks to resolve COVID-19 related commercial contractual disputes in conjunction with the Oyo State Multi-Door Conference, the Lagos Chamber of Commerce, the International Arbitration Center, and International Center for Arbitration and Mediation, Abuja. As a fledgling lawyer, she calls her team at ROA Ogunwole Chief Advocate of Nigeria, where she gained profound litigation experience, moving thereafter to prime solicitors in digitalized law firm, where her soliciting expertise was honed and her passion for digital law practice was ignited. Immediately before starting up Abbey Legal Barristers and Solicitors, she worked at Orlanium and Orlanium, where she rose to become the head of chapter. Abi holds the Bachelor of Law degree from North American University, where she graduated as the youngest in her class, and she also attended North American University in Benin Republic, I think, where she graduated as the youngest in her class, and she also attended the Nigerian Law School Abuja campus, where she graduated at the age of 21. She holds a she holds a Master of Law degree from the University of Ibadan, and she is a member of the Nigerian Bar Association. In the bid to gain a better grasp of her line of practice, she has gained 2 certifications in online mediation, website designing, digital marketing, and graphics designing. Her contributions to legal practice have been highly recognized in the Nigerian legal industry, making her a recipient of various awards. One, the Nigerian Bar Association YLF Honorary Award 2024. Nigerian Bar Association Women Forum National Conference Panelist Award 2023. FIDA Africa Regional Congress Panelist Award 2023. 100 Most Influential Lawyers in Nigeria 2023 by Simplex Academy. Good Workers International Young Achievers Award 2023. FBI Awards of Influence and Professionalism 2023. Top 50 Outstanding Legal Luminaries in Nigeria 2022 by Simplex Academy. Oyo State Humanity Grant 2022 awarded to her law firm Abbey Legal, sorry. Top 50 Outstanding Legal Luminaries in Nigeria 2022 by Simplex Academy. Contributions to Legal Profession Awards 21. In March 2023, she was also nominated as one of the top 3 exceptional Nigerian women in law practice by Tewa Awards. Ladies and gentlemen, may I have the singular honor to introduce to you our guest speaker today, Abimo Toyes Olayiwola.
So thank you.
After that rather brilliant and elaborate introduction of our guest speaker, I think it is only imperative that before she gives a speech, we also get to know the people on this stage. My name is Idris Mohammed. I'm the former secretary of the Nigerian Bar Association Kaduna branch.
and my chairman is busy looking at me here. I'm loyal. I'd like to thank the executive and the planning committee of the Law Week of the Nigerian Bar Association, Barnawa, for inviting me. And I am very grateful for this invitation. I'd like to start by introducing this panel. We're going to make it very interactive. I have a couple of slides. Benzi, can you pick up my slides, please? So the topic for this discussion is digital lawyers of our time redirecting law practice. The first or second slide I have are things that are pulled from social media about this very rich panel that we have. Benzi, next slide. So these are our speakers. Abiyamo Toyosi Oguyemo, Alami Abubakar, Sharon Yabo Kuyet, and Frank Ijigi. Next slide, please. Now, this is a very interesting thing I called up from the internet about Abiyamo. This is our speaking, and I'm sure by the time she gets to know, go into the speech itself, you will get to hear more about it. Here she's talking about how many years she has had to do different kinds of practices before she settled on being a digital lawyer. She'll be sharing her experience on that. Next slide, please. Now, this is Alami. Alami is sitting right next to me. This is his Facebook page, and he has like different description of himself. First of all, is what? That he wrote in Arabic. It means a student of knowledge. Apart from all of this, there's also the last one that he puts there, and it's written in Hausa. Can you say it out loud and tell us the meaning? Okay, it's Karamban. What does it mean? It means I can venture into almost anything as the spirit leads me. It also means stubborn, doesn't it? So are you stubborn? Also, he has 10 different things that he's doing. The next one is that of Benzi. Please, can I have your attention and put this for me, please? So that this thing will go smoothly. Can we have the next slide? Okay, this is the one of very pretty Sharon. And this is from our Instagram page. And this is from where she just recently graduated, and she was promising all our followers that she would tell them all about law school. So right now, she has already finished doing that, and she's already sitting on the stage talking about digital lawyering. I think that is quite remarkable. You were called in 2020, right? She was called in 2019. 5 years onwards, she has developed skills for her to be on this stage. Well done, Sharon. The next person is Frank Ijigi. Can I have the next slide, please? Yes, Frank Ijigi. Now, Frank says too many things on Twitter, is a regular commentator. But I picked this one particularly because he says digital rights is a fundamental right, and goes on to make comments about what is happening in Libya, Afghanistan. So the question would be, what section of the Constitution recognizes our digital rights as fundamental rights? Frank, apart from the many other things that you said on Twitter, I know you are like a bulldozer there. So, what section of the Constitution says digital rights are constitutional rights? Hold your thoughts. We'll get to that discussion. Having said all of this, may I now invite Abiyamo Toyosi to present our paper. Abiyamo, for those of you that do not have not heard of her, has a program she calls the Digital Lawyer. It is like a boot camp where people go and get trained, lawyers in particular, go and get trained on digital skills. But I am sure by the time you finish hearing her, you'll be able to fully appreciate the things that she does. So if she's there, Abiyamo, please go ahead and present your paper. Thank you.
Thank you so much, sir. I really appreciate you. I want to appreciate the chairman of the Cardinal Bar, the vice chairman, and the executive committee of this Law Week for this opportunity to speak at this event. Please, I want to know if I am audible enough for the event and if I can go on with my presentation.
Yes, you are audible enough. Please continue.
Thank you, sir. Thank you, sir. So my name is Abimo Olayiwola, and I'm a business lawyer and a digital law practice consultant. And I'm so happy today to be presenting on the topic, Digital Lawyer of Our Time, Redirecting Law Practice Digitally. We all know that all professions, including the legal profession, is currently undergoing a significant transformation driven by technology. In fact, I would even call it a revolution, because if there is any industry that is not going the tech way right now, it means that that industry is going to go extinct any moment from now, because they won't be able to cater to the clients of today. The clients of today are now tech driven. They are now digital clients. The way they do their things, the way they get their services is now connected to technology and digital tools. So now, lawyers who key into this tech revolution and who use digital
To remove the mic.
skills.
To remove the mic.
Lawyers who click into this tech revolution and use digital tools, they have the opportunity to read a wider audience. They have the opportunity to improve their efficiency, and they have the opportunity to grow their law practice faster than their contemporaries. And that is why we teach about digital law practice. What do I mean by digital law practice? Digital law practice is simply
It's out already,
people.
bro. Then he should mute himself. Therefore, he should mute himself.
Please, can I speak on? So what is digital law practice? Digital law practice is basically leveraging digital and technological tools to streamline our law practice. And this involves using online platforms like online legal research, using platforms like online platform like the one I am using now to communicate for clients communication, leveraging on document management with cloud-based solutions, using legal service automation tools to automate repetitive tasks, and then leveraging on digital marketing tools to get clients online. That is basically what we mean when we are talking about digital law practice. Now, digital law practice will benefit a law firm in a number of ways. The first thing is increased efficiency and time saving. There are a lot of legal tools that can help lawyers to automate repetitive tasks like document generation. You would agree with me that as lawyers, we deal with a lot of documents, whether we are drafting agreements, whether we are drafting court processes, whether we are creating any form of document. Most of our documents are, are templates that we pass down to generations, from generations to generations. So what if we can actually use legal, what if we can actually use technological tools to automate this document generation so that we can save more time and make our work more efficient? Another thing is legal research. Take legal research for an example. When I started my law practice, I was working in a law firm whereby we used to have, a very big library. And in that library, we would use ladders to climb the shelf of the law firm before we could get law reports. And even after spending hours, finding law reports, and you are happy that you are able to get a law report, you will find out that there's another law report that supersedes that. But all those things are no longer like that again, thanks to technology. Because right now, with technology, you can have increased efficiency. At the click of a button, we have a lot of online law reporting platforms like Legopedia, like Law Pavilion, and all of them. Another thing is scheduling your task. So lawyers would always tell me that they are very busy people and they don't have the time to go on social media to post when they are supposed to be in court, where they are supposed to be handling client meetings. Now, what I tell lawyers is that there are automation tools that you can use to schedule your social media management. So you can create a lot of posts that you intend to share, and then you automate the post to share automatically without you being present. So whether you are in court or you are at home or you are in the office, people would see that your post is going up. People would engage with your post, but actually you are not there. As I am speaking presently, there is a Facebook post that is going out and people are commenting, and I'm seeing notifications on my phone. I am here speaking and the post is going out. So that is what we call that's what we call automation. So it helps you to schedule your post. So it helps you to free up, your valuable time so that you can have more time to do better things that would bring in the money. Another thing is it helps you to reduce overhead costs when you have a cloud-based, solution. Before now, firms used to, they needed a big space for paper documents. So you must have a big storage facility for your files. I remember when I was, with my principal, there are times that would have, big bags because we are going to court, and, all the files would just be so bulky, paper files and everything. And the challenge with having such bulky paper files is that it can get lost, it can get missing, it can even get destroyed by fire or any particular type of disaster, acts of God, it can get destroyed. But if you leverage on cloud storage as a lawyer, if you leverage on cloud storage, you can store your documents virtually and they are protected in the cloud. You don't have to go to court carrying every files, every document. Everything can be on your tab, it can be on your phone, it can be on your laptop. And even when you need to get information, instant information about the case you are handling, a client is calling you or asking for something about the case you are handling, you can generally just pick up your phone, your tab, or your laptop, and then you log in to the client's portal on the cloud storage, and then you have access to the whole information. Tell it not in this age that a lawyer will be telling a client that I have to get to the office before I can get an update on your case. I have to get to the office before I can give you a feedback on your case. It is no longer the situation thanks to cloud management or cloud storage management. So you have to be able to use that. Another thing is it expands your market reach. So we tell lawyers that you can use social media, you can use search engine, and you can use your websites to reach clients over the internet. So you can actually reach a wider range of people beyond your geographical location, beyond your nose bridge. There are a lot of lawyers that are very brilliant, super brilliant. They have a lot of track record and everything, but they won't be able to get international opportunities because they have no digital footprints. They have nothing to show on search engine, on social media. They have nothing to show the level of their brilliance. So you did a case today, you won, you did this, you have a great track record. But if we search online for lawyers who are good in that particular area, for law firms that are very good in that your particular area, are we going to find you on search engine? Are we going to find you on social media? A lot of lawyers would not be found. And the unfortunate thing is that some lawyers who are not as good as you are, or some law firms who do not have your track record, are leveraging these digital tools. They are leveraging the online space. And when they do that, people only contact people that they know, they see. They see you today, they'll be like, oh, this lawyer, this law firm is good. They know you, they like you, they trust you, and then they give opportunities. But if you are so good, but you are a secret, you are a best secret, you are in obscurity, nobody's going to bring international opportunities to you. You may be getting opportunities in your geographical location, but when it comes to a global opportunity, the lawyer is not going to get it. I have a friend who is actually a very young lawyer, but she's always talking about business law on Facebook. Guess what? She got invited from, Kenya, the central bank. They invited her to come and speak at their tech festival about business law and startups. And it was all expenses paid. Before you know it, it blew up on the internet. And that was what led to her setting up her law practice in Lagos, because as at then, she was actually a young lawyer. She didn't even have a law practice of her own. So she was able to get that international opportunity because she leveraged Facebook. As at the time she did that, she didn't know so much. She was young. There are a lot of senior lawyers who are more knowledgeable than she is, but they turned to Facebook, they searched, and the only name they found is actually her name. Or probably her name was the first name they saw, and they gave her that opportunity. So it gives you a very wide, opportunity. You are able to reach a global audience. Then another thing is it increases your profitability. When you leverage, the internet, statistics says that, according to data reporter, statistics says that we have over 5 billion internet users. Over 5 billion people. So it means that anytime you leverage the internet for your law firm, you are having opportunity to meet over 5 billion people. That is increased productivity. Over 5 billion people know about your expertise. They know about what you can do, and they can bring briefs to you. Another thing that I tell lawyers is that it is not only services that lawyers can offer. Lawyers can also offer products. And I ask lawyers, you are a very brilliant lawyer. Your law practice area is good. But can we say that you have a book? Do you have a book to stamp your authority in your practice area? Do you have an online course? Do you have a program? Do you have a checklist? Do you have anything that can cement your authority in your practice area? And that is what we call productization. So I encourage lawyers to productize their services. You don't only sell services, you package your legal knowledge into products like your books, like your courses, like your trainings, like your checklists, like your mentorship programs, and then you sell it over the internet. Personally, I have a program that I do for my business law practice. It's called the Legally Fortified Business course. The Legally Fortified Business. And guess what? A lot of people subscribe to this course, and that is me packaging my legal knowledge and selling it, productizing it. It makes me to reach more people, and it brings in more profits. And another thing is, there is only a little, a little number of people that you can reach with services. Like, how many people can I really serve one on one? But when I create a product, I can have 1,000 people buy my product. I can have 5,000 people buy my product. One, I am gaining more popularity. More people are getting to know about my brand. Then two, I am also making more profit for my brand. And another thing is I am eliminating brain pickers. Because if you come and meet me now and tell me, oh, lawyer, can I just ask you this question? I'll tell you, I have that question as an ebook. I've answered that question as an ebook. I've answered that question as a course, as an online course. Please get it. So it helps me to also eliminate brain pickers. Now, if you want to leverage digital tools, there are some things that you have to focus on. There are some things that you have to focus on. Number one is your case management software. You have to be able to organize your task, your deadlines, manage your clients efficiently. I understand the Law Pavilion as a case management software. There's another one, Case Tracker, and a lot of them. So you have to be able to use it. Recently, I also taught lawyers how they can use Google Workspace to effectively manage their law practice. So I realized that most of the lawyers that I am dealing with, they are, solo practitioners and people who have small law firms, and they may not be able to afford all these expensive software. So I taught them, it was a free class. I taught them how they can actually use Google Workspace to effectively manage their law practice. But if you are a big law firm and you can do it, please get good case management softwares. Then invest in document automations. You don't have to bore your staff or yourself with repetitive tasks. At the Digital Lawyers Network, we have a course called the Digital Lawyers Bootcamp. We teach lawyers how they can set up their own personal AI legal assistants in English language. And these assistants can help them to do some repetitive tasks so that they can free up time. Because time is money. Time is very important. Another one is legal research. You must be sure that you are using online research platforms. Then the last one is communication. Clients do not have to walk into your office for you to communicate with them. Personally, most of my clients, I communicate with them online. I am communicating with the Kaduna Bar online presently. So what stops me from communicating with my clients online? It makes my work faster and more efficient. Then another thing is the cloud storage service. You must be able to get your cloud storage so that you don't go around with bulky files. Even if you go around with bulky files, be sure that you have a backup on the cloud in case of any disaster, or in case you need to, lay your hands on it immediately. Another one is legal practice digital marketing tools. You have to be able to use digital marketing tools. You have to be able to use digital marketing platforms like social media. What we experience.
Sorry, hold on.
Thank you so much. You just have. Thank you.
Please go ahead.
Thank you so much. Thank you. So another thing is legal practice digital marketing tools.
5 more minutes, please.
5 more minutes. Thank you. As a lawyer or a law firm, you must be able to leverage on social media. You must be able to leverage on social media platforms to grow your digital footprint. But lawyers and law firms often tell us that, oh, we are very busy people and we can't do that. And so at the Digital Lawyers Network, we manage lawyers, we manage law firms. We help them to create a very good digital footprint in line with the rules of professional conduct, because we are lawyers and then we understand the rules of digital marketing. So we are able to combine it. So another thing is your website. That I will just round up with that. A lot of law firms, I know they now have a website, but they don't have a user-friendly website. So they just have a kind of a static information website where you can just go to and just read about them. No, it must be interactive. People must be able to come to your website without having to, speak with you at all. And then they can schedule consultation, they can make payments. If you are doing maybe business law or something, they should be able to get all their information, fill a form, make payments, and get their services delivered to them without having to contact you at all. Then with that, you would say that, oh, you are redirecting your law practice digitally. And those are the things that we teach at the Digital Lawyers Bootcamp. If you would like to learn about digital lawyering in Nigeria or beyond the shores of Nigeria, I would encourage you to sign up for the Digital Lawyers Bootcamp. I don't know if my slide is being shared, but I made my slide available and it can be shared to everybody. Thank you for this opportunity. I really appreciate the Kaduna Bar. Thank you.
I've been one of the people that have been pushing and creating opportunities in the digital law practice. Just a quick summation of the things that she said. She mentioned automation tools that you can use in your office. About going into whether it's negates or goes against our rules of professional conduct. And advantages to it, she mentioned increased efficiency, document generation. And one thing that I am very conscious about is I see a lot, and one of our panelists will answer the question when I start it out. In the social media space. No, I'm back. To go even whether it's solicited or unsolicited advice in social media. Would I have, if I have already given an advice on the social media space, be entitled to my fees as relates to the remuneration order? So, without wasting much of our time, I've divided this topic into three basic thematic concerns, and I'll be asking the questions to the panelists based on this. Then we quickly go to Q&A, and we answer those questions directly to the speaker and to any of the members of the discussants. The first thematic concern I think I would like everybody to share their thoughts on is Abiyamo has done a great job about talking about the use of digital tools to improve legal practice. So let me start with you, Frank. You comment quite a lot on the X, like say X. You want to say Twitter. So you comment quite a lot on the on that space. Your commentary there, is it in a way to improve your legal practice, or is it just your own way of having social commentary on topical issues? And then the second question, has that in any way helped you to enhance your legal practice?
My chairman, distinguished senior advocates of Nigeria, eminent seniors, and distinguished colleagues. Good afternoon. I'm grateful for this opportunity. Actually, as a lawyer, in today's generation, one must leverage on technology to be able to do your practice. As a matter of fact, go to courts in Kaduna, the moment they see me, they begin to shout digital lawyer. Because I have instituted a lot of cases in that light, and recently I got the Federal High Court to decide that access to the internet is part of fundamental rights. I comment on social media most times because it gives me the exposure and sometimes free publicity. Apart from the fact that I also use the internet and social media to comment on national, to make my opinion known, it has also boosted my practice, to be honest. I have had people who just maybe they contact me on WhatsApp And when I say, who referred you? They say, no, I saw your work online. That is why I contacted you to have the service. And it has really placed me in some significant financial position because you know how our practice is, especially for a growing lawyer like myself. Not be able to fit in when I want to compete with some of these eminent seniors, but because I have been able to use that opportunity that technology has offered, it has been able to keep me afloat. And lawyers must leverage on technology. We cannot continue to resist technology to succeed in today's practice. That's the truth. Yesterday we were here, Justice Ibrahim Buba said, when WhatsApp started, the initial plan was that judges should avoid WhatsApp. But today, most rules of the courts have incorporated this as a means of even serving the other parties. So why are we resisting? Why are we not out there on the internet? I am actually a student of it. I'm very grateful she's here because I was one of those who participated at how to use the flow-based training. And it said my idea and how I can actually leverage more on technology. There are also other trainings offered on digital law practice. And I don't know why, especially most of us in this part of country, we do not really take digital law practice serious. That is a problem. If you go online, there are lawyers who are out there talking, especially Lagos lawyers. I sometimes wonder what we here are doing. I was conversing with a senior advocate of Nigeria some time ago, and he said while they were doing the election petitions, when they serve processes, they ask them to go and bring up a draft. He said there was a particular lawyer, in 24 hours or less than 24 hours, he comes up with a draft. And the senior advocate was like, Augusta, how do you do this? Is it that you don't sleep at all? The man said, don't worry, don't worry. If they give another assignment, if they want to do it, the lawyer from Lagos will say, don't worry, I'll prepare. Then this one will go back. The next morning he will come. A draft was prepared. Sir, how did you read through this entire process? It was later he discovered that they were using technology to be able to come up with this process. We in the northern part, especially we have a lot to do. Permit me to say, all modesty, a lot of catch up to do if we want to compete with some of these lawyers out there. We cannot continue to rely on the old order or old way of doing things. If you go online and search for most lawyers, they are not even on it. That is the sad truth. So we prefer to carry books, we prefer to wait for clients to walk into the office and all. When you can just, as little as even posting your picture, writing a little thing about what you have done or what you have achieved, and clients will run into your inbox asking you for your legal opinion. So answering your question and summarizing, I have been able to use technology and I will continue to use technology to enhance my practice. However, there's also the opportunity for acquiring education because you ought to know what to post and what not to post so that you don't run foul of the RPC. And most times we are even afraid of commenting because we don't want to offend the RPC. A lawyer is not allowed to have opinions. You can have an opinion on an issue, write about it, and share it online. As a matter of fact, we heard that people that said someone was writing about business law, she was invited, she was sharing her opinion. That's one way to enhance your practice, and you don't know how RPC. Great.
Thank you so much. How about you, Sharon? As a young lawyer, how has technology helped you in your practice?
Seniors and me. So concerning the question that was asked, technology or revision of physical meetings. Let me give manager and I said here. So there were some people who have never been to the north. Because we interacted in law school and then even after law school, we kept in touch. We were following each other on Instagram, we followed each other on Twitter. Some of them had agreed to be and that was around the time that we
Lunch now. Let's go to lunch. You go.
some of them
Then
had
you
fairy
come back to
tales
the house. I will go.
to share
I'm
with some
going to
of
the
them.
hospital.
So the fear of driving to Kaduna prevented a lot of them from coming. So it was during that time that many of them had friends in Kaduna. So we could split the bills. And sometimes if I felt that I couldn't handle it, I would call some senior lawyers and refer them. And then the agreement is that you give me your own share, my own share of the profit and that. And that has really helped a lot because like he also said, sometimes people get to know, oh yeah, it's just jurisdiction, let me call you so that you can work for me. I also do it once in a while on my WhatsApp stories to I noticed that a lot of Nigerians don't know their rights as basic as you have the freedom of life and to defend yourself and all that. So by the time you post those things, people are interested and they ask you questions. And there are certain questions they ask you that you tell them that, oh, you will have to pay before I tell you. Some will laugh about it. While there are others that will take you serious. So they
all like
you know your money. Especially as a lawyer that uses digital tools. For example, Google and Zoom, Google Zoom, YouTube. These tools are very, very helpful. So on my own, sometimes I've never held a program or a seminar, but on my own, when I'm interacting with people, sometimes I get that, oh, that's impressive. How do you know these things? And I've come to realize that law is holistic. Everything about this life has law. Even nature has laws that if you follow or you don't follow, there are consequences for it. So we don't just approach our legal practice in the aspect of just giving them solutions legally. You have to approach it holistically. A lawyer is a businessman. You know, some people believe that if you don't go to court, you are not a lawyer. But we have some people that, especially for lawyers that are coming out of Nigerian laws recently, some of them don't go to court, but they are influencers online and they are making money and they are also providing solutions to their clients because they are talking on legal aspects of everything. We have tech lawyers that are coming up and as a lawyer, we're not just limiting ourselves, but that has actually helped me to improve my knowledge, not just on legal things, but even different things, so that I can make sure that I satisfy my clients and at the same time I can also make sure my pockets are fat.
I like the last part that your pocket is fat. So it's very important, and she has mentioned something which is a growing trend now. That's content creation. If you go on Instagram, there's this guy, Lai Wasabi. He's earning millions from what he does. Although he's caricaturing lawyers, he's earning millions and he has been endorsing products online. There's so many of them. There's so many of them online that are content creators and are creating a lot of content. I'll go to the next thing and I'll come to you, Abami. So the next thematic concern is now we have spoken about digital tools. There's so many things that technology and the internet is throwing up that needs lawyers to even interpret on them. I'll give you a couple of examples. Data protection. Just until recently, data protection was not anything. Now we have a data protection commission in Nigeria that protects data. There's data privacy. There's cybersecurity, which is a very wild field. There's also I, with all modesty, made a lot of money there from telecommunications. And these things have different types of regulation. There's also intellectual property. But without going too much into that, I know you own a law firm. So you talk to us on two things. How does digital tools help you? And what are the areas of technology that you are focusing on to also enhance your practice?
Thank you very much. Permit me to stand on existing protocol. I would like to start from this dimension. This information technology is a solution to almost everything you can think of. The sky is the limit. All you need to do is think, and the solution is there. There is hardly any imagination you will have in your head that technology is not there to solve for you. For example, how are we all coping with the recent hike in cost of transportation? In my office, for example, when cost of transportation was going up and lawyers were clamoring for more money and everybody was making his own complaint. It's simple. I don't need you physically in office for the whole 5 days. What are you coming to do? The most important thing is I will assign tasks to you. You finish your task and you submit to me. I can take 3 days without going to the office, and sometimes lawyers will complain, you are not seeing me. I just know I'm born well anyhow. That is why you are not seeing me. Truly. So I stay at home, I do my work, or I assign somebody to do the work. You send it, I vet it, I send to another person to print, I send to another person to sign, send to another person to go and file. And at the end of the day, it's still the same process that will be filed, regardless of what you know about it. And it comes with this freedom that you even get to think better. Like I have a friend that says he thinks better when he's wearing his shorts and singlet at home. So sometimes when he drafts process in the office, when he comes home and he's not wearing anything and he's looking at it, that is when he sees all the mistakes and everything. So that is just one thing that technology can do for you. Secondly, with the recent introduction, with the recent listing of artificial intelligence, you see, we need to sit down and understand where is this artificial intelligence heading to. It has gone to the extent that if you really know what you are doing with artificial intelligence, I keep telling people, artificial intelligence is as intelligent as you are. If you are dull, you will get dull results from artificial intelligence. If you are intelligent, you get intelligent results. Because the prompts and the instructions you are going to give AI will determine the kind of response you will get. You can go as far as, many people don't know that you can go as far as telling AI to draft a process for you. And that is what the speaker is talking about, automated practices. I can just, in fact, it happened recently. I was in court for a bail application. Unknown to me, a counter affidavit was filed in the evening, and we are two separate lawyers handling the matter, and it was served on the other lawyer who did not inform me. But when I was in court in the morning, lo and behold, they've not brought the accused. The judge insisted that the accused must come. So, and then the matter was stood down to wait for the accused. And here is counter affidavit. And I want that bail application to go on that day. So I went outside and I told ChatGPT, draft a further and better affidavit for me, state this, and it was just oral instruction. And within seconds, everything was there. All I needed is just to edit. And then I found the nearest place, I printed it, and then I gave it to the deponent to sign, and it was filed. And by the time we returned to court, when the accused was available, I've served my further and better affidavits. However, we should be mindful of also certain things. We should be mindful of privacy. You see, this our regulation, this our profession is highly regulated. So you should be mindful of what information you are storing there. For example, the Panama Papers scandal, it was information that linked from a law firm. So you should also be mindful, what kind of security are you having to protect you? You should know that if you are using free tools, my dear, your data is the resources, your data is the money. They are using your data. No matter how, whether you understand it or you don't understand it, data is money. So learn where you are putting your data and what kind of data you are putting. For some basic cases that you know will just
finish a roundup, it's understandable. But if, for example, you are representing total share, please and please be mindful of the kind of information you supply online. Before you know it, somebody will be there and then you will be scandalized seriously. So there are many things I would have wanted to say that the time here will not be enough. But I want to add to this. Try as much as possible. Take it as your responsibility from here. Resolve that every day, you will go to YouTube. Instead of you going there to watch dancing videos and people showing different parts of their bodies, take it as a responsibility every day, 20 minutes a day of YouTube videos to learn a new digital skills. Many of us here, if we are going to write exams, how we use Microsoft Word, just this ordinary Microsoft Word, to draft our processes, many of us here will not be graded well. That is the truth. You see processes being drafted, the formatting is very poor. And it's not, so people will just because you have computer, you can open Microsoft Word, you just start typing. But there are certain things you will do to make your work elegant, smart, and it will look very legal. Your pagination, there is a way of, for example, if you are drafting your statement of claim, and then after your statement of claim, it's your witness statement and quotes. If, for example, your statement of claim is from page 1 to 5, you want your witness statement and quotes to start from another page 1 to 5. How do you break it? And then on the same document, and it will be there. So all these things are advanced things that when you go to YouTube, you just ask these questions and you will get videos that will show you exactly how you will go about it. How do you embrace cloud system of storing your files so that your files will be online wherever you are? All you need to do is to print, and then you just access it, edit, and print. The automation, how do you automate repetitive tasks? Go to YouTube, ask. Go to ChatGPT, ask. And the lectures will just be there for you free of charge. And it will save you a lot of time, a lot of stress. Then on a final note, as we use technology, we should also be mindful of our health. There are so many illnesses that come with excessive use of technology. We should be mindful of our eyes. Using screen at night, for example, when you have started sleeping, just anybody can just observe you have started sleeping, and then suddenly you wake up and then you wanted to check time, then you check time. Sometimes it will be harder for you to go back to sleep. Simply because those rays that enter your eyes, they trigger something in your brain that it is morning already. And before you know it, in the morning, you'll be having headache and so many other things. So be mindful of it and try as much as possible to avoid it. There is spondylosis. It's a pain on the neck as a result of, we are turning to zombies. Everybody is always like this, watching this phone. So the spinal cord, especially at the neck, we call them lumbars, L1, L2, the doctors will tell you. So they get issues after some time, and then it will cost a lot of money, and sometimes even after spending money, you still not get better. So these are the things that we should put into consideration as we continue to be digital lawyers. Thank you very much.
Thank you so much, Alabi. I was already thinking that apart from your law degree, I have an MBBS, so you are already mentioning numbers and giving the description. Thank you so much. Very deep and insightful contribution. You made mention of automation of messages. I'm sure we already know that we are in a dictionary campaign, and by today or the next few days, you'll be receiving a lot of automated messages. These messages are just programmed. You just go online on the program, on a particular software, put that message and say that you should put this set of numbers at this particular time. And while they are even sleeping, you will be receiving those messages. The second issue, I'll come back to you, Frank, has to do with cybercrime. Technology has its different components and its different sides. There's also the bad side. In recognition of this, the Cyber Crimes Act that we all know them as Yahoo boys. What they essentially do is take advantage of technology. So can you just give us an insight? This is an area
where you must have some form of specialty and you must know some form of coding or some form of internet manipulation before you can do it. Give us a little insight. I know I've seen that you've written on it before. On the cyber crimes, kind of offenses that you could have there. If you have any difficulty, you can just pass the mic back.
Every good thing has a bad side. We appreciate light because there's darkness. And we appreciate sunlight because there's rain. The same thing with digital law practice. There's high tendency for it to be abused. There's also the high tendency for your privacy to be breached. There's also the high tendency for criminals to take advantage and use it to commit crimes and offenses. So the Cybercrime Act has tried to categorize certain aspects or conducts on the internet as crimes. For instance, we have issues like advanced fee fraud. We have issues of cyber stalking and cyber bullying. As a matter of fact, just yesterday, someone reached out to me about cyber stalking and cyber bullying. There are offenses for it, and these are the bad sides of the internet. And if you like, maybe digital law practice, like Alan said while he was speaking, if you have information of your clients, you should guard them jealously. I think even Abimbola mentioned it. So, because there are criminals or there are people who they experience sleepless nights in trying to ensure that they cause harm to you. So, as you embrace this technology, you should also be wary of that aspect. And you should do everything you can to protect your information. One of the best ways to do that is to have antivirus to ensure that they cannot crack into your system. I'm not familiar with coding, but you can have a very strong antivirus system that will prevent your maybe your cloud storage and maybe document generation and every other thing to be hacked, so that they will not access your information and sell some of this data to the wrong people. I think that's what.
Thank you so much. Thank you so much. I mentioned this earlier, and I'm going to be directing that question to Sharon because I see you like the representative of the Gen Z, the content creation people, the people that go online and abuse us as lawyers. You see a lot of those, you guys call it clips or what do you call it? Online, reels online, where they're caricaturing lawyers. I hope that we could turn that. And if Maoga Mazi comes into office, he could use that also to project us. These reels have massive views, massive. And the way I've read about publicity stunts carried out by companies using reels, and you would not know that they are trying to sell their products. I'll give you an example. How many of us have heard of Pampe? When Pampe first of all came out, they started bringing out reels, which they sponsored, that if you take their loan and do not pay, they will come after you. They were passing a message that once you take our loan, you have to pay. There were a lot of views in that direction, and I think it is something that we can consider as a profession because our image is very critical. If we could also use it, imagine us having reels that are saying that if you stay a lawyer, the remuneration order says you must pay X, Y, Z, and it's repeatedly shown across all social media platforms. The people receiving that reel will automatically know. They create the impression. It's perception that lawyers, you must pay for them. As opposed to what we have presently now, which is the fact that the caricaturing Alamin is when he's seeing his clients, he sees them under the tree. So, on content creation, what do you think is the future? Just give us your perspective.
Thank you, sir. For content creation, you have largely answered it, but my own take about it is while there are bad sides to things, you should also project the good side. There's this content creator, apropos doctor. I think he's actually a doctor, but he's not practicing. But anytime you go through his content, he's always telling you the advantages and disadvantages of certain health styles, certain lifestyles, health benefits, what you eat and what you don't eat. So this guy in Wasabi that he's talking about, I'm not sure if he's a lawyer, but he always caricatures lawyers in a funny way. Sometimes those things are actually true. Some things can be painfully true. Maybe you see a lawyer has been practicing for so many years and is looking ruggedy, and then you see that it's not because he has not had good cases, but because his approach, he has not integrated things like this digitization, or he just feels like he has to follow a particular tradition. And you know, lawyers who can be very traditional. We as lawyers, we that know what is true, we that know what is good, and we that know what is trending, we can also do our own reels where we can have weekly vlogs that maybe talks about like if there's a law that just was passed, we can talk about it. I know some people that do that. There's this lawyer. There are so many of them on X that always do that. If there's a new act that has been passed, they talk about what it entails and what it doesn't. And then I feel like even we on our WhatsApps too, we can do that. If you can preach on your WhatsApp story, or you can tell people what you are doing daily, you can also make it a habit that if you know something, like for example now, there are certain things we argue about. We say that, oh, police do not have right to ask us for our car papers if that car is not reasonably suspected to have been stolen. You can go to the police act, and then on your WhatsApp once in a while you post the rights of a citizen when a policeman stops you. That way now you are subtly encouraging or teaching someone something. So we can't just say because someone makes a caricature of our profession, even if there are some things that we are saying that may be true, but they might be exaggerated. We as lawyers have our own parts to play, especially for those that know their onions. Thank you.
Thank you so much, Sharon. Very, very well said. So we'll be rounding up these sessions, but I would like some last comments from my panelists. First, there's a very critical issue. What is the curriculum of our education? That's on legal education. Is technology a part of it? Is ICT, information and communications technology, a part of it? What are your views and what do you think we should do on that front?
Thank you for the opportunity once again. I'm happy we have aspirants to the position of president of the NBA. We also have distinguished life lecturers in our midst. The truth is that the kind of curriculum we train lawyers with today cannot fit into the present world. We are graduating lawyers with a decade-old knowledge, and yet we complain that lawyers are outdated. We need to visit our curriculum, amend it to reflect the present exigencies and the present legal needs that we have. You cannot graduate a lawyer, or a lawyer cannot graduate today. I'm asking him, he doesn't know anything about the emerging areas of law. He doesn't know anything about intellectual property. We're doing legalities, property law. Even at the university level, some of the courses that we were taught at universities, the curriculum was designed as far back as 1990. And I'm graduating in 2014 with a knowledge of 1990. How do I fix it? As a lawyer, I cannot do anything about it. The leaders of the bar, the bulk is on your table with greatest respect to ensure that we reform our legal education so that lawyers that we produce today and tomorrow will be able to compete globally with their peers and contemporaries around the world. Thank you.
That's a very, very solid point. I'll get back to you again. What are the specifics, things that you need needs to be included in the legal education. Like you just said, we have two life versions and that's reference to the NDA. So we are passing a message across to them. What are those specific things that you feel should be included into our higher education now?
Thank you very much. For instance, digital law or digital skills, they are very, very important. Digital skills. There are also other areas of law. You have intellectual property, which you mentioned, you have privacy, you have data protection. There are so many, there's sports law. I know someone who has made a fortune from sports law. I recall there's entertainment law. As a matter of fact, I recall while I was in university, a classmate of mine was writing his project in sports law, and I laughed at him. I said, what do you think you can do with sports law? But today I know better. So our leaders at the bar, this is a modest challenge to you with greatest respect. I hope my child will become a lawyer tomorrow. I don't want my child to graduate as a lawyer with a knowledge of 2014. And we cannot sleep on this because you find situations where even when we have certain aspects of law and legal issues come up, we still have to bring in lawyers from outside to come and handle these cases. It is an insult on us, honestly, with greatest respect. We must rise up to the challenge. We must ensure, we must appreciate the fact that society is evolving, legal practice is evolving, and we must encourage this change in our legal education so that the legal practice in Nigeria can be up there. I recall recently there was an issue where even the NBA president had to react where they said the minister, I can't remember quickly, has allowed lawyers from outside to practice in Nigeria, lawyers from the UK. And there was uproar. A lot of people said this and that, but you see, it is because expertise in certain aspects of practice globally are missing in Nigeria. And that is why the few who have taken the challenge to acquire education are making it big.
That is a very, very valid point. Legal outsourcing is a huge market in Nigeria, and a lot of these briefs do not come to us local lawyers. I know for a fact that as of last year, based on a study conducted independently, NNPC, all those big corporations that have the big and mega briefs, have retained UK-based lawyers to provide advice to them on these things. It was last valued at about 300 million US dollars. Locally here, this is a personal experience. With the Kaduna state government under the previous administration, our firm was regularly used by big law firms in Lagos, and then they will now be giving you the peanuts of it all. Help us conduct search now. Your office, I've checked it on Google, it's very close to the to Cadis. Just go across, just help us. So this year, recently, the same law firm briefed us and said we should help. And I told Zainab that I should give them a charge of 1.5 million. They now rushed back and started calling me. I said, yes, I was the one that told her to do it. He now said, okay, I'll get back to you. Till date, they haven't gotten back. They probably are looking for another person that they will use to do that same thing. Then when it comes to the time for us to go for the big meetings and to sit on the same things, they never call us. They fly because we also they will become friendly with them. So they will tell us, I'm in town, no, come and see me. And when you ask them what have you come for, I'm having a meeting with the Kaduna State government, blah, blah, blah. What it tells me is that I have not built the capacity. And so I have to develop those capacities in order for us to be called to the same table. And I give that as a challenge to all of those. Personal development is very critical. It's not only for you to sit and assume that I know. The sphere of lawyering now is very wide and dependent. Okay, on the final one to Alali, the judiciary, we have a lot of magistrates here present. what are those things that used by the judiciary to enhance justice delivery? Yes, thank you very much for this question. It's actually very substantially for the judiciary. I think the problem are already enormous. They are so much, and substantially, we will not get anywhere close to solving those problems until when the judiciary becomes fully autonomous. So that is basic and it's fundamental. But in the process, for example, as a judge or as a magistrate, it's incumbent upon you to leverage on tools within your means. First of all, if there is a way you can clamor for the government to provide these tools, but I think your mouth will go longer and they will still not provide. So on your own, there are things within your phones, within your laptop that you can use that are very, very basic to improving your work. For example, if you are writing a judgment, if you are writing your judgment, there are simple tools that can summarize your trials for you, summarize arguments of counsels, summarize plaintiff's arguments, summarize defendant's arguments. And in fact, the only thing you can even highlight your conclusions, do the skeleton, input it, and it will flesh it up for you. And truth be told, if you are adopting some of these methods, you will grow white hair not as fast as your other colleagues who are doing everything in shorthand. And also, insist that lawyers should provide you soft copies of their address. The era where lawyers will continue to come to your work, you're already doing too much. Honestly, everybody knows. So insist that lawyers should provide you soft copies of their arguments. Just put these two arguments together, get an automated system to summarize it, but always check. Like Honorable Justice Buba said yesterday, don't go and be cutting and be pasting everything anyhow. One day you face very big trouble for yourself. So always check thoroughly what have you pasted. And also, you can also try as much as possible to synchronize your calendar, even for lawyers. Ordinary Google Calendar can help you synchronize calendar. If the registry adds a new case and they update the new case on their own diary, you should be able to see it. And when they are putting in a date on Google Calendar, they will see the dates that you already have in your court. And they will be able to effectively get dates that are going to manage your time efficiently. These are things that you don't need the government to do. Almost everybody now has a smartphone. So there are only things you educate your registry. Use Google Calendar to store dates. When you are giving dates, you update it. As soon as you update it, the judge's calendar will have that. Other people in the court that have access to that calendar will have that. The same thing in a law firm. If, for example, as I'm sitting here, my lawyer that went to Kano for a case picks a date, automatically I'll see it on my calendar. And if I'm in court and I've seen that, okay, Monday next week is no longer available, probably if I'm not going for the matter again, then I will pick Monday and I will pick another date based on what is there in my calendar. We don't have to come back to off Friday and everybody bringing his diary. Okay, let's update my diary. We have passed that age and there is no reason why we should be going back to that age. These are just the simple things. And God's willing, I will see the possibility with some of the panelists here. Let's find time to do a proper seminar, even if it is just for 2 hours. And for some of these things to break them down properly so that some of us can assimilate it and make our works easier. Thank you. That is so true. I was pinching you, whispering, mention the tools, mention the tools. So mention the tool.
Yes, for summarization, the commonest one, ChatGPT, it's enough. And then there are so many of those artificial intelligence devices. In fact, there are artificial intelligence devices that you can train on your own style, on your own way of doing things.
and you will be able to they will be able to listen to you and work as your legal assistant. Yes.
Um, AI is even so basic now. On your WhatsApp, if you go to the search button, WhatsApp that all of us use, ask it any question. It's better AI. Ask it any question, it should give you an answer. Any question. That's like everybody here has said, very careful. Review the answer given to you before sending it out. The future. I just received a comment from each of them after I made. What is the future of technology in the legal profession? Biggest future I see, and is a trend that global AI. It will present so many challenges. There are many challenges as relates to intellectual property of AI. Who owns that document that you have generated from AI? Then you as a lawyer, how do you interface with AI? One very critical software tool that he has mentioned is ChatGPT. ChatGPT can learn the way you write. It can summarize documents for you. It can draft from you by learning from previous documents that you have already uploaded to it. And it's simple. For instance, for motion, right? Just upload like 3 different motions, and the prompts will just study these prompts and prepare documents for me using this stuff, right? I will now allow each of the panelists, before we go to Q&A quickly, to now tell us what they think the future should be like for lawyers in Nigeria, and particularly in Kaduna State with technology. I'll start with you, Sharon.
For me, the future of legal practice is now, not tomorrow. But already it's because of the benefits that we are here, have a Zoom and we have all this. So I would desire that at the comfort of our homes, we can still have court processing. And we've made sure that everybody is satisfied, the clients and the legal practitioners themselves with the judges. And most especially, there should still be justice, there should be organized, and everyone who's happy.
I think for me, the future and technology is part of that future. However, we cannot adopt technology hook, line, and sinker. And on our part, prepared what we call should be an AI regulation bill. And we have made contact with some people in the National Assembly. We are still trying to see how we can convince them so that we can regulate what we are consuming. Lawyers should not consider AI as a competitor. Collaborate with AI or technology and enhance your practice. Thank you.
I've been thinking ever since the moderator mentioned what is the future. Honestly, I have 2 answers. We are already in the future, and it's moving very fast. So it's just to be safe, get on board, because the train is moving so fast and it's going to either crush anything on its way or carry anything that wants to go on board. So the choice is ours.
At the last stage before this, I was on the panel talking about AI, and I mentioned something that made a lot of people cringe. And that was the fact that I said that are we at the beginning of another evolution? We should really consider this in making our regulations. Because once you are taking those computers, is that you are teaching them how to think like humans. In fact, some of their answers are way deeper than what you and I will produce. The next level is now they are teaching how to express feelings, love. And now, in the IoT, in the Internet of Things, that is where these communications, we're already having it with our phones. There's inanimate things like your AC can discuss with your car, can discuss with your fridge. It's already happening. There's a fridge now that if you remove milk from a particular place, it automatically orders milk for you because you have consumed it. It's happening. Amazon has created a store that you just walk in, pick things off the shelf, and walk out. Your account with Amazon is automatically debited. We are living our lives now based on technology. So there's two sides to it. But finally, I would like to thank everyone for giving us their time and listening to us. This has been a very young panel. Abiyamo is still all the way from Ibadan. Alamin, Frank, Cheryl, and myself, thank you so much for your attention. Okay. So we'll do like 2 or 3 questions, particularly for the speaker. Lunch is already ready, and we'll quickly round up. Are there any questions? Lenny Simpson.
Mr. Chairman, thank you for giving to your question. And the mic. Sorry, my own is not a question. I don't even have a minute to me. 1 or 2 comments. Let me thank the speaker and all of you young men who have done justice to this very important topic for discussion. My take is that today's topic is the foundation upon which the theme of this law week is rested. Without technology in place, we cannot have advantage of time to enhance justice delivery. Now, I was moved by Frank's comment when he pointedly described how the practice of lawyers in this profession, how practice is at the lowest ebb in comparison to our colleagues in Lagos and other institutions. He hit the nail on the head by stating that we are not leveraging on technology. We are still very much soaked in the analog era. And that's why I would say with all sense of modesty that the level of economic fortune for lawyers in this jurisdiction is not growing at all. Those of us at this level, we are exiting, we are going. Whether we like it or not, we have to leave the stage, either because of old age, sickness, or even death. It is basic. Majority of those whom we met here have exited. So those of you just coming behind us, we need to open your eyes. We need to open your ears so that you will learn to quickly embrace technology. As a matter of fact, today's program is an eye-opener, and it is giving you advance notice that unless you embrace technology, you will not be able to fit into core litigation in this jurisdiction. I say this because
a brand new High Court civil procedure rules will soon be promulgated. I'm lucky to have served in the committee for review of that. I can tell you for free that 80% of the content of that rules is technology driven. So if you want to be part of progress of your practice, quickly go and dust your learning of technology. Now there will be e-filing, there will be trial by Zoom, judgment to be delivered by Zoom, services of processes will now be powered through WhatsApp, SMS, and email. If you are not into technology, tell me, how do you fit into that? The same thing goes to the practice at magistrate level. In this position, when you have a matter, a little matter in mind, they are looking at the principle of your own rules of thought, which has become moribund, will also enjoy a total overhaul. So, ladies and gentlemen, let us embrace technology because that is what keeps on keeping the food for our family. Thank you very much.
Chair of session, you called for question, but permit me to make a comment instead. When I listen to Frank and Sharon, I think that my take away from it is that our learning remains us. And the curriculum for training pilots is still outdated. It has not been reviewed to its modern realities. And our own thinking too is that because we have a law degree, we can only earn a living as well. And I think that the acknowledgement that technology is already with us because we utilize it in so many areas. And in fact, that's about more than 70% of the lawyers who join the profession every year may never get employment. Means that most lawyers will have to find ways of being self-reliant, being entrepreneurial, and that means thinking beyond the borders. Meaning that they have to think beyond the norm of how people earn. So, because the education system is geared towards producing people for the employment market, so you see students trying to make a first class so that they can get into certain firms or certain companies. We must realize that those who drive the world are the entrepreneurs, those who work for themselves, who create businesses and employ others, not the employees. And so to the extent that there may not be enough jobs, that the economy is bad, you must find ways of making money beyond the normal ways of going to court, doing agreement, doing this, doing that. So my take from this is that redirecting legal practice should also be redirecting our thinking and how we earn a living. And we have to know that technology is at the thing of our speed, that the fact that we have a phone gives us access to many possibilities, and we shouldn't limit ourselves. And to the extent that these are not criminal or unethical, that we can also do some other things while not being lawyers and contribute to the society. And so that's why I bristle at the idea that because the person is a lawyer, he or she does certain things on the internet, and we will send on the person and take their BDC. For that person to amount to professional misconduct, I think you have to be carrying on the practice of law at the same time as you're doing that. But even though you have a law degree, in some other thing, which in some context may not be in sync with the status of a lawyer, to the extent that you're not practicing law, you should be free to do that and earn a living and broaden your perspective and contribute to the body of knowledge. Thank you so very much.
Thank you so much, Lenesi. Coming from an aspirant for the presidency, we immediately see the direction that the legal profession may be going if you read. Yes, we just take after him one more launches. Okay, after him, you, after him, you. Then. Please introduce yourself.
All right. Good afternoon, everyone. My name is CC Frank. Standing on the existing protocol, I want to say thank you very much for everyone for the panel and everything that I've shared with us. I'm very, very grateful to have learned a lot from what you've shared. I have a question, but before I give the question, before I ask the question, I just want to make some comments. I happen to have had interest in technology from a very long, right from even my year one, because of my brother was into it and everything. Developed interest for programming, currently into network security engineering. But I observed that I love that towards the end, Alamin was able to bring in the aspect of the judiciary. That's because we were very much, initially we were very much focused on the part of the lawyers, the case management and everything, but I loved that towards the end, we were able to bring in the judiciary. And I will now say the practices that we've talked about for the lawyers, I'm saying that we can extrapolate the same practice to the judiciary as well. These case management systems can be very much employed by the judiciary. We're looking at things like AI text to AI speech to text. It can be used in courtrooms. So you can have personally trained models, large language models used in the courtroom. So what it just needs to be yes, sir. Thank you. All right, sir. And with regards, I noticed that with regards to personal service and all that, there's usually issue with regards to I've always been cracking my head how can the issue of personal service be solved? And I'm saying we can use I'm just suggesting systems like the same technology that is for smart contracts. It can also be employed in personal services. Then with regards to the AI, one question that I think I'm very Frank, with regards to the AI, I think one thing that we should really consider as AI is becoming very prominent in this, we need to consider the aspect of liability, because the actions of AI will be responsible for them. It's a very proactive approach, and I would love to be part of that. I really want to be.
Okay.
Then my question. All right. Okay. Thank you very much.
Thank you so much.
That's the question.
No, thank you. Introduce yourself.
My name is Adam Adi. I want to add to what Adam said about the judiciary. I work in and we have a situation where some of our judges now type their judgment directly. They don't do longhand anymore. So we have situations where some lawyers will file their briefs without submitting flash or soft copy in any form. So there are times since I started working with them, I personally reach out to these lawyers. Please send me your briefs because I will need to summarize and then forward to my lord so that your judgment can be ready in time. Fortunately, some lawyers don't respond. Some will tell me they don't have soft copies and stories like that. So I'm just saying, for the benefit of everybody, these things delay your judgment because some of them don't write in time. So it's easier when you submit your briefs. But if you don't submit your briefs, before you please send something, please send.
Well, thank you so much for that. Correct me if I'm wrong. The Court of Appeal rules has a rule that says you must submit soft copy together with the brief. Correct me if I'm wrong.
You are correct.
So we take your information and very well taken. And I think there should be some form of enforcement with the Court of Appeal not to accept a brief for filing without the soft copy attached to it. That's a simple solution, not to accept it for filing without the soft copy. Thank you so much. I think at this stage we're done. So thank you enormously for your contribution.
A round of applause please for the chairman of the session, Idris Mohammed Esquire, my learned friend Alamina Abubakar, Frank Ijeke, and Sharon Yabukuyet. Please a round of applause for them. Before the photograph session, I would like to call on the chairman of the lobbying committee and the person of Bukola Ajao to come and give a vote of thanks. Please a round of applause for her. It's not easy to organize such a wonderful event, each free and knowledge packed. Thank you very much. Please a round of applause for her. Thank you.
Good afternoon. Good afternoon. You can see that I'm smiling from here this side, and it's because I'm so excited. This is the first time that I will be witnessing, not because I'm the chairman of this committee, but the fact that we had a large number of lawyers seated from yesterday to today. I would especially appreciate magistrates. Honestly, I'm overwhelmed with their presence because we sent the letter through their chairman and we're all here to just. I would like to thank our guest speaker, Ambassador Shegun Owiyawo. Is a good teacher and he taught me and ensured he pushed me till I got my fellow in the Institute of Mediators and Conciliators. And I appreciate you, sir. I also appreciate our learned students here. I like to tell you, Olanoja SAN, Rashid SAN, my lords that are here. I appreciate the chairman, Mr. Idris, at a very short notice he was here. And I wonder, I just want to say something about digital lawyer. I don't know her before, but because I also engaged on maybe social media, that was where I met her. I've been following her, and I met her at the regional conference of women lawyers in Abuja 2023. So I approached her, I told her that I've been following you and I love the way you create your content on Facebook. And we got talking. And so when we were preparing for this long week, and on the theme, essence of time, I realized that you can't talk about time without talking about digital. And you cannot talk about time without looking at ADR. And you cannot talk about time without ensuring that the lawyers, the court, and the litigants are represented. And as such, you now ask yourself, whose time? Is it the litigants? Is it the court? Or is it the lawyer? And that was how we're able to come up with all these three topics that are all interrelated and speaking of essence of time. I would like to thank the executive members of Barnawa Law branch for giving me the opportunity to serve as the chairman of this Law Week Planning Committee. I'll thank the chairman, my old classmate, V.A. Yewuze, for giving me this opportunity. When they approached me, honestly, it was just a month. I just lost my dad 2 months before he told me that, Buki, I want you to chair this lobbying committee. I said, you know, I'm just coming back from my father's bed. Your father is called Buki, you will do it. And I thank God for all the members of the committee. I would especially appreciate everyone in that committee. I would like to appreciate Tony Rashida Oguji. She's a very strong member of the committee, talking about Joro Iwagalachi, already the secretary of NBA Barnawa branch. And I also thank the secretary of the committee, Wazuncho. You can call him anytime he's there. For all the other members of the committee, I thank you all for your time during this planning. We appreciate all the discussants. Thank you very much. Adeline, thank you. Frank Ijeke, thank you. Our own Sharon, thank you. And lastly, I would like to call the chairman, Barrister B.A. to come and present the plan for our guest speaker, Adi Moteosi. I don't know if she's still listening to us. Mr. Ben, is she still online? All right, thank you.
Then, please, I think you have not appreciated enough the chairman of this law will committee standing before you here, Bukola Ajao Esquire. Please, can we appreciate her heavily? Just as she rightly stated, barely a month from the burial of our father, I approached her and said, "You must do this, not that you do this." And being my comment, my personal friend, my neighbor, and my confidant, she accepted. And that is why we had this wonderful law. We are going to present plaques in appreciation of our guest speaker on this topic of the area. I mean, the digital royalty. As a matter of fact, we carefully chose this speaker, being a lead consultant in Digital Lawyers Network. And because of our personal relationship with the chairperson of the Law Week, she accepted. And she has done justice to this topic. Can we appreciate her? Coincidentally, she delivered the paper virtually, but she has a representative in the chairperson of the Law Week. She will stand out to receive that flag. Mine is to organize and arrange the giving of flag. Permit me to call upon the life bencher, senior advocate of Nigeria, a very elder member of the branch, a leader of sorts. I do call him also my guardian, mentor, and facilitator in all ramifications. Please join me in welcoming on this podium our amiable, highly revered Alhaji Tajuddin Latini Olaroya. Alhaji sir, you are welcome to the podium to present this plan to our speaker, Adimo Toyoshi Olayiwola, lead consultant Digital Lawyers Network, every represented here by Bukola Ajao Esquire, the chairperson of the law. Right.
Thank you, Mr. Chairman. On behalf of leadership and the entire membership of the Nigerian Association and our branch, the model branch, we are very glad to have Adimo Toyosi Olayiwola in our midst through the assistance of technology. We enjoyed your presentation quite well, and then you can rest assured that you've given all of us so many things to go home with. In appreciation, in profound appreciation of your robust presentation as the lead speaker, on behalf of the branch, we hereby present to you a plaque in recognition of your eloquence and recognition of your great industry. We present it to you by proxy through your friend Bukola Ajao Esquire, the chairman of the 2024 Law Week. Mrs. Bogala will give you this for onward transmission. Congratulations. Congratulations. Congratulations.
Thank you very much. The man with the greatest heart, large, very large heart. The life venture, senior educator of Nigeria, Raji, Ajuddin. Please let us appreciate the Raji. On the beginning of the certificates to every discussers, the moderator and chairman of the session, my own very good friend is, and by grace, the next chairman of the APA. Please come here, please. I'm taking it because as a chairman, I reliably tell you who be a chairman. So that's the next chairman of the branch. Please appreciate it. But if some of you are sitting out my prophecies, if you want to tell the next chairman of the model branch who is going to succeed, I'll tell you at the conference. Thank you very much. I will say no. So be another topic of discussion another time. So for the presentation of the certificates, if you notice that one of our eldest member of this branch was not going to come to this project. Somebody else will come and represent him in this project. Another elder member of this branch, the mother branch, who has been very prompt, very and consistent in attending meetings and activities, including the local meeting from yesterday and previous. Please permit me to welcome on the podium our own elder, Hamidu Lawa Esquire. Please, podium to present the certificates. Is that clap enough for him? You are very welcome. The first person is the moderator of this particular session. Idris Mohammed Espa.
May I, on behalf of General Grant Association, present to you this certificate for participation to Idris Mohammed Espa.
The next beneficiary of this beautiful is our own GSA member, Alamin Abubakar Esquire. But I must tell you one thing about this young man here. We vividly remember during the COVID-19 period when there was a lockdown and there was no physical meetings or anything. He was the one that early and effectively arranged virtual meeting of the branch throughout that period. And again, I try to be corrected. Now, the person that is going to present it to him is our special guest, Mazi Aham Osigwe, senior editor Life Venture, past General Secretary of the Nigerian Association, current Chairman, MPA Remuneration Committee. Mazi has been a very good friend of the branch. I've been here since. Mazi, please do this rest of the presentation.
I mean, I'm like, I know that was a very beautiful presentation. My on behalf of the Nigerian Bar Association, present the certificate of participation to you. Recognition of your participation as a discussant. Digital way of our time, directing law practice, during the branches 2004. You guys are sharing examples of what best The next person is Steve. That's why we're in model branch. Honestly, if we leave the potentials we have in our branch, there will be commotion in the entire state. Once again, well known for his wisdom knowledge is Frank Ijege, who has just been unopposed nominated and presented as the public secretary of the model branch in Congress. Frank Ijege, I have the honor to present the certificate of participation to you on behalf of the Nigerian Bar Association of Barnawa Law, which I got discovered that you soon say as secretary. And the certificate is a recognition of your participation as a discussant on the topic of digital law of our time, directing law practice through the practice to follow. I say your contributions were very insightful, were excellent, were thought-provoking, and they were life-changing. Thank you so very much. Then, Martin is not done, please. Another person, or you don't like to give this person? Okay. I told you what we are going to do in the model branch. Another person, well known for digital knowledge. If you look at the resource persons, they were internally sourced. We didn't go outside the branch to bring them, except the Idris Mohammed that so our on Yabo Kuyes Esquire. If you're able to pray, please, I'm sure you'll sign on. Sharon, Yabo Kuyes. Oh my God. I wish I could. Oh, yeah. I'd like to do all of what you guys do. You're doing a great job. I have the honor of presenting certificate of participation to you on behalf of the Nigerian Bar Association Barnawa branch, the Barnawa branch, the recognition of your outstanding participation, all of them, as a discussant for the topic, digital law of our time, the directing law practice due practice 2024 annual. Let's say that discussion reminded me that all of us have giants within us. And sometimes we need to reawaken that giant if the giant is asleep. That for us to realize our potentials, we must think of doing some other things or doing the things we are doing different. And I'm indeed challenged by them because it made me realize that I could still do more in aspect of legal practice. Thank you very much for inviting me. My left lecture, let us see my relatives. Obviously, just to allow the speaker, the honorable ambassador, to say one or two things before we wrap up. Please, we want to hear from you. Please, I want to appreciate you as well.
By the time it's done, okay, the lead presenter, I said that we should allow the guest speaker online to say one or two things before you now say his own. So, are you online?
Yes, I am online. Yes, I am online.
Okay.
I didn't get that correctly, sir.
You want to say something to us?
Okay, I really want to appreciate the Cardinal Bar for this opportunity and for the gift. Also, I want to say that the future of legal practice belongs to legal technologists, people who can combine their legal skills with technological skills to provide real life solutions. And I implore all lawyers to take legal skills as important as to take technological skills as important as their legal skills, because we are now in the era of legal technologies, people who can use legal skills and technological skills to provide real life solutions. Thank you so much.
Some of us here may not know that you are very young at the bar, but what you have achieved so far within the short period is so much that you are a pride to the Nigerian Bar Association. But what you have achieved so far, now
to go, she can.
now speaker, let me tell you. Someone you can sit very close to us.
I didn't even know.
When the discussion was going, you said different areas of your life. The first was it's making a change kind of way. Yet you and thank you for the sacrifice. Thank you. That is what leadership is all about. That's self-sacrifices. I want to thank the NEO, meeting of us for this push. I thank you. One year to our association for having online training from the morning, training yesterday, this up till now, and not all they are done. What do we say? We you cannot help keeping our records. This marks the elders. So thank you very much. You know that you also privilege and honor to have in our midst the excellency of police state that has not that never remained governor of police state. Former past chairman of Nigerian Bar Association branch is the president of Council Audi. Can you wish him up the page? Yes, we are doing the sponsorship in the hands. So if anything happens to you, as a person, come on. So, Mazi, please come on. No. Madam Anito, where is God there? Please, we also welcome one of our seniors. Some of you don't have the privilege of knowing him. The only reason